The Constitution of the State of Nevada, narrated by Dr. John S. Petrick, Assembly Candidate for District 21. The Nevada Constitution was framed by a convention of delegates chosen by the people. The convention met at Carson City on July 4, 1864, and adjourned on July 28th of the same year. On the first Wednesday of September 1864, the Constitution was approved by the vote of the people of the Territory of Nevada, and on October 31st, 1864, President Lincoln proclaimed the state of Nevada was admitted into the Union on an equal footing with the original states. Article 1. Article 1, Declaration of Rights. Section 1, Inalienable Rights. All men are by nature free and equal, and have certain inalienable rights, among which are those of enjoying and defending life and liberty, acquiring and possessing and protecting property, and pursuing and obtaining safety and happiness. Section 2. Purpose of government. Paramount allegiance to the United States. All political power is inherent in the people. Government is instituted for the protection, security, and benefit of the people, and they have the right to alter or reform the same whenever the public good may require it. But the paramount allegiance of every citizen is due to the federal government in the exercise of all its constitutional powers, as the same have been or may be defined by the Supreme Court of the United States. And no power exists in the people of this or any other state of the federal union to dissolve their connection therewith or perform any act tending to impair, subvert, or resist the Supreme Court's authority of the government of the United States. The Constitution of the United States confers full power on the federal government to maintain and perpetuate its existence, and whensoever any portion of the states or people thereof attempt to secede from the federal union or forcibly resist the execution of its laws, the federal government may, by warrant of the Constitution, employ the armed forces in compelling obedience to its authority. Section 3. Trial by jury. Waiver in civil cases. The right of trial by jury shall be secured to all and remain inviolate forever, but by a jury trial may be waived by the parties in all civil cases in the manner to be prescribed by law. And in civil cases, if 3/4 of the jurors agree upon a verdict, it shall stand, and have the same force and effect as if it verdict by the whole jury, provided the legislature, by a law passed by 2/3 vote of all the members elected to each branch thereof, may require a unanimous verdict notwithstanding this provision. Section 4. Liberty of conscience. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed in this state, and no person shall be rendered incompetent to be a witness on account of his opinions on matters of his religious beliefs. But the liberty of conscience hereby secured shall not be construed as to excuse acts of licentiousness or justify practices inconsistent with the peace or safety of this state. Section 5. Suspension of habeas corpus. The privilege of writ of habeas corpus shall not be suspended unless when in a case of rebellion or invasion the public safety may require its suspension. Section 6. Excessive bail and fines, cruel or unusual punishment in detention of witnesses. Excessive bail shall not be required, nor excessive fines imposed, nor shall cruel or unusual punishments be inflicted, nor shall witnesses be unreasonably detained. Section 7. Bail. Exception for capital offenses and certain murders. All persons shall be bailable by sufficient sureties unless the capital offenses or murders punishable by life imprisonment without the possibility of parole when the proof is evident or the presumption great. Section 8. Rights of accused in criminal prosecutions, jeopardy, due process of law, and eminent domain. 1. No person shall be tried for a capital or other infamous crime except in cases of impeachment and in cases of militia when in actual service and the land and naval forces in time of war, or which this state may keep with consent of Congress in time of peace, and in cases of petit larceny, under the regulation of legislature, except on presentment of indictment of the grand jury or upon information duly filed by a district attorney or attorney general of the state. And in any trial and in any court whatever, the party accused shall be allowed to appear and defend in person, and with counsel, as civil actions. No person shall be subject to be twice put in jeopardy for the same offense, nor shall he be compelled in any criminal case to be a witness against himself. 2. No person shall be deprived of life, liberty, or property without due process of law. 3. Private property shall not be taken for public use without just compensation having been first made or secured, except in cases of war, riot, fire, or great public peril, in which cases compensation shall be afterwards made. Section 8A. Rights of the victim of crime. 1. Each person who is a victim of crime is entitled to the following rights. A. To be treated with fairness and respect for his or her privacy and dignity, and to be free of intimidation, harassment, and abuse throughout the criminal or juvenile justice process. B. To be reasonably protected from the defendant and persons acting on behalf of the defendant. C. To have the safety of the victim and the victim's family considered as a factor in fixing the amount of bail and release conditions for the defendant. D. To prevent the disclosure of confidential information or records to the defendant which could be used to locate or harass the victim or the victim's family. E. To refuse an interview or deposition requested unless under court order, and to set reasonable conditions on the conduct of any such interview to which the victim consents. F. To reasonably confer with the prosecuting agency upon request regarding the case. G. To reasonable notice of all public proceedings, including delinquency proceedings upon request, at which the defendant and the prosecutor are entitled to be present, and of all parole or other post-conviction release proceedings, and to be present at all such proceedings. H. To be reasonably heard upon request at any public proceedings, including delinquency proceedings in any court invoking release or sentencing, and at any parole proceeding. I. To a timely disposition of case following the arrest of the defendant. J. To provide information to any public officer or employee conducting a pre-sentence investigation concerning the impact of the offense on the victim and the victim's family, and any sentencing recommendations before the sentencing of the defendant. K. To be informed upon request of the conviction, sentence, place and time of incarceration, or any other disposition of the defendant, the scheduled release date of the defendant, and the release of or the escape by the defendant from custody. L. To full and timely restitution. M. To prompt return of legal property when no longer needed as evidence. N. To be informed of all post-conviction proceedings, to participate and provide information to the parole authority, to be considered before the parole of the offender, and to be notified upon request of the parole or other release of the offender. O. To have the safety of the victim's family, and the general public considered before any parole or other post-judgment release decision is made. P. To have all the monetary payments, money, and property collected from any person who has been ordered to make restitution be first applied to pay the amounts ordered as restitution to the victim. Q. To be specifically informed of the rights enumerated in this section, and to have information concerning those rights be made available to the general public. Number 2. A victim has standing to assert the rights enumerated in this section in any court with jurisdiction over the case. The court shall promptly rule on a victim's request. A defendant does not have standing to assert the rights of his or her victim. The section does not alter the powers, duties, or responsibilities of the prosecuting attorney. A victim does not have the status of a party in a criminal proceeding. Number 3. Except as otherwise provided in subsection 4, no person may maintain an action against the state or any public officer or employee for damages or injunctive, declaratory, or other legal or equitable relief on behalf of the victim of crime as a result of a violation of this section or any statute enacted by the legislature pursuant thereto. No such violation authorizes setting aside a conviction. Number 4. A person may maintain an action to compel a public officer or employee to carry out any duty required by this section or any statute enacted by the legislature pursuant thereto. Number 5. The granting of these rights to victims must not be construed to deny or disparage other rights possessed by victims. A parole authority shall extend the right to be heard at a parole hearing to any person harmed by the offender. Number 6. The legislature shall by law provide any other measure necessary or useful to secure to victims of crime the benefit of the rights set forth in this section. 7. As used in this section, victim means any person directly and proximately harmed by a commission of a criminal offense under any law of this state. If the victim is less than 18 years of age, incompetent, incapacitated, or deceased, the term includes the legal guardian of the victim or a representative of the victim's estate, members of the victim's family, or any other person who is appointed by the court to act on the victim's behalf, except that the court shall not appoint the defendant as such a person. Section 9. Liberty of speech and the press. Every citizen may freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of that right, and no law shall be passed to restrain or abridge the liberty of speech or of the press. In all criminal prosecutions and civil actions for libels, the truth may be given in evidence to the jury, and if it shall appear to the jury that the matter charged as libelous is true, and was published with good motives and for justifiable ends, the party shall be acquitted or exonerated. Section 10. Right to assemble and to petition. The people shall have the right freely to assemble together, to consult for the common good, to instruct their representatives, and to petition the legislature for redress of grievances. Section 11. The right to keep and bear arms. Civil power supreme. Number 1. Every citizen has the right to keep and bear arms for the security and defense, for lawful hunting, recreational use, and for other lawful purposes. Number 2. The military shall be subordinate to the civil power. No standing army shall be maintained by this state in the time of peace. In the time of war, no appropriation for a standing army shall be for longer than 2 years. Section 12. Quartering soldier in private house. No soldier shall in the time of peace be quartered in any house without the consent of the owner, nor in the time of war, except in the manner to be prescribed by law. Section 13. Representation apportioned according to population. Representation shall be apportioned according to population. Section 14. Exemption of property from execution, imprisonment for debt. The privilege of the debtor to enjoy the necessary comforts of life shall be recognized by wholesome laws, exempting a reasonable amount of property from seizure or sale for the payment of any debts or liabilities hereafter contracted. And there shall be no imprisonment for debt, except in cases of fraud, libel, or slander, and no person shall be imprisoned for a militia fine in time of peace. Section 15. Bill of Attainder, ex post facto law, obligation of contract. No bill of attainder, ex post facto law, or law impairing the obligation of contract shall be passed. Section 16. Rights of foreigners. This was repealed in 1924. Section 17. Slavery and involuntary servitude prohibited. Neither slavery nor involuntary servitude, unless for the punishment of crimes, shall be ever tolerated in this state. Section 18, Unreasonable Seizure and Search, Issuance of Warrants. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable seizures and searches shall not be violated, and no warrant shall issue but a probable cause, supported by oath or affirmation, particularly describe the place or places to be searched, and the person or persons, and the thing or things to be seized. Section 19, Treason. Treason against the state shall consist only in levying war against it, adhering to its enemies, or giving them aid and comfort. And no person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or a confession in open court. Section 20. Rights retained by people. This enumeration of rights shall not be construed to impair or deny others retained by the people. Section 21. Recognition of marriage. The state of Nevada and its political subdivisions shall recognize marriages and issue marriage licenses to couples regardless of gender. Religious organizations and members of the clergy have the right to refuse to solemnize a marriage, and no person has the right to make any claim against a religious organization or member of the clergy for such a refusal. Number 3. All legally valid marriages must be treated equally under the law. Section 22. Eminent domain proceedings, restrictions, and requirements. Notwithstanding any other provision of this Constitution to the contrary. Number 1. Public use shall not include the direct or indirect transfer of any interest in property taken in an eminent domain proceeding from one private party to another private party. In all eminent domain actions, the government shall have the burden to prove public use. Number 2. In all eminent domain actions, prior to the government's occupancy, a property owner shall be given copies of all appraisals by the government and shall be entitled, at the property owner's election, to a separate and distinct determination by a district court jury as to whether the taking is actually for a public use. Number 3. If a public use is determined, the taken or damaged property shall be valued at the highest and best use without considering any future dedication requirements imposed by the government. If private property is taken for any proprietary governmental purpose, then the property shall be valued at the use to which the government intends to put the property, if such use results in a higher value for the land taken. Number 4. In all eminent domain actions, just compensation shall be defined as the sum of money necessary to place the property owner back in the same position monetarily, without any governmental offsets, as if the property had never been taken. Just compensation shall include, but is not limited to, compounded interest and all reasonable costs and expenses actually incurred. Number 5. In all eminent domain actions where fair market value is applied, it shall be defined as the highest price the property would bring on the open market. Number 6. Property taken in eminent domain shall automatically revert back to the original property owner upon repayment of the original purchase price, if the property is not used within 5 years from the original purpose stated by the government. The 5 years shall begin running from the date of entry of the final order of condemnation. Number 7. A property owner shall not be liable to the government for attorney's fees or costs in any eminent domain action. Number 8. For all provisions contained in this section, government shall be defined as the state of Nevada, its political subdivisions and agencies, and any public or private agent acting on their behalf, and any public or private entity that has the power of eminent domain. Number 9. Any provision contained in this section shall be deemed a separate and freestanding right and shall remain in full force and effect should any other provision contained in this section be stricken for any reason. Section 24. Equality of rights. Equality of rights under the law shall not be denied or abridged by the state or any of its political subdivisions on account of race, color, creed, sex, sexual orientation, gender identity or expression, age, disability, ancestry, or national origin. Article 2. Right of suffrage. Section 1. Right to vote. Qualifications of elector. Qualifications of non-elector to vote for President and Vice President of the United States. Section 1. Right to vote. Qualifications of elector. Qualifications of non-elector to vote for President and Vice President of the United States. All citizens of the United States not laboring under the disabilities named in this Constitution, of the age of 18 years and upwards, who shall have actually and not constructively resided in the state 6 months, and in the district or county 30 days next preceding any election, shall be entitled to vote for all officers that now or hereafter may be elected by the state, and upon all questions submitted to the electors at such election, provided that no person who has been or may be convicted of treason or felony in any state or territory of the United States, unless restored to civil rights, and no person who has been adjudicated mentally incompetent, unless restored to legal capacity, shall be entitled to the privilege of an elector. There shall be no denial of an elective franchise at any election on account of sex. The legislature may provide by law conditions under which a citizen of the United States who does not have the status of an elector in another state and who does not meet the resident requirements of this section may be a vote in the state for the President and Vice President of the United States. Section 1A. Rights of Voters. Each voter who is qualified elector under this Constitution and is registered to vote in accordance with Section 6 of this article and the laws enacted by legislature pursuant thereto has the right: 1. To receive and cast a ballot that a. is written in a format that allows the clear identification of candidates, and b. accurately records the voter's preference in the selection of candidates. 2. To have questions concerning voting procedures answered, and to have an explanation of the procedures for voting posted in a conspicuous place at all polling places. 3. To vote without being intimidated, threatened, or coerced. 4. To vote during any period for early voting or on election day if the voter is waiting in line at a polling place at which, by law, the voter is entitled to vote at the time that the polls close and the voter has not already cast a vote in that election. 5. To return a spoiled ballot and receive another ballot in its place. 6. To request assistance in voting if necessary. 7. To a sample ballot which is accurate, informative, and delivered in a timely manner as provided by law. 8. To receive instruction in the use of equipment by voting during any period for early voting or on election day. 9. To equal access to the election system without discrimination, including without limitation, discrimination on the basis of race, age, disability, military service, employment, or overseas residence. 10. To a uniform, statewide standard for counting and recounting all votes accurately as provided by law. 11. To have complaints about elections and election contests resolved fairly, accurately, and efficiently as provided by law. Section 2. When residence not gained or lost. For the purpose of voting, no person shall be deemed to have gained or lost a residence solely by reason of his presence or absence while employed in the service of the United States, nor while engaged in the navigation of the waters of the United States or of the high seas, nor while a student of any institution of learning, nor while kept at any charitable institution or medical facility at public expense, nor while confined in any public prison. Section 3. Armed Forces Personnel. This was repealed in 1972. Section 4. Privilege of qualified electors on general election day, during the day of which any general election shall be held in the state, no qualified elector shall be arrested by virtue of any civil process. Section 5. Voting by ballot. Voting in elections by legislature. All elections by the people shall be by ballot, and all elections by the legislature or by either branch thereof shall be viva voce. Section 6. Registration of electors, test of electoral qualifications. Provision shall be made by law for the registration of the names of electors within the counties of which they may be residents, and for the ascertainment by proper proofs of the persons who shall be entitled to the right of suffrage, as hereby established, to preserve the purity of elections, and to regulate the manner of holding and making returns of the same. And the legislature shall have power to prescribe by law any other or further rules or oaths as may be deemed necessary as a test of electoral qualification. Section 7. Poll tax, levy and purpose. This was repealed in 1966. Section 8. Qualifications of voters on adoption or rejection of Constitution. All persons qualified by law to vote for representatives to the General Assembly of the Territory of Nevada on the 21st day of March A.D. 1864, and all other persons who may be lawful voters in said territory on the first Wednesday of September next following, shall be entitled to vote directly upon the question of adopting or rejecting this Constitution. Section 9. Recall of public officers, procedure and limitations. Every public officer in the state of Nevada is subject, as herein provided, to recall from office by the registered voters of the state, or of the county, district, or municipality which he represents. For this purpose, not less than 25% of the number who actually voted in the state or in the county, district, or municipality which he represents at the election in which he was elected shall file their petition, in the manner herein provided, demanding his recall by the people. They shall set forth in said petition, in not exceeding 200 words, the reasons why said recall is demanded. If he shall offer his resignation, it shall be accepted and take effect on the day it was offered, and the vacancy thereby caused shall be filled in the manner provided by law. If he shall not resign within 5 days after the petition is filed, a special election shall be ordered to be held within 30 days after the issuance of the call therefor, in the state or county, district, or municipality electing said officer, to determine whether the people will recall said officer. On the ballot at said election shall be printed verbatim as set forth in the recall petition, the reasons for demanding the recall of said officer, and in not more than 200 words the officer's justification of his course in office. He shall continue to perform the duties of his office until the result of said election shall be finally declared. Other candidates for the office may be nominated to be voted for at said special election. The candidate who shall receive the highest number of votes at said special election shall be deemed elected for the remainder of the term, whether it be the person against whom the recall petition was filed or another. The recall petition shall be filed with the other officer with whom the petition for nomination to such office shall be filed, and the same officer shall be ordered the special election within its required. No such petition shall be circulated or filed against any officer until he has actually held his office 6 months, and save and except that may be filed against a senator or assemblyman in the legislature at the time after 10 days from the beginning of the first session, after his election. After one such petition and special election, no further recall petition shall be filed against the same officer during the term for which he was elected, unless such further petitioners shall pay into the public treasury from which the expenses of the said special election have been paid, the whole amount paid out of said public treasury as expenses for the preceding special election. Such additional legislation as may aid the operation of this section shall be provided by law. Section 10. Limitation on contributions to campaign. 1. As used in this section, contribution includes the value of services provided in kind for which money would otherwise be paid, such as paid polling and resulting data, paid direct mail, paid solicitation by phone, and any paid campaign paraphernalia printed or otherwise produced, and the use of paid personnel to assist in a campaign. Number 2. The legislature shall provide by law for the limitation of the total contribution of any natural or artificial person to the campaign of any person for election to any office, except a federal office, to $5,000 for the primary and $5,000 for the general election, and to be the approval or rejection of any question by the registered voters to $5,000, whether the office sought or the question submitted is local or for the state as a whole. The legislature shall further provide for the punishment of the contributor, the candidate, and any other knowing party to a violation of the limit as a felony. Article 3, Distribution of Powers. Section 1, 3 separate departments, separation of powers, legislative review of the administrative regulations. Number 1. The power of the government of the state of Nevada shall be divided into 3 separate departments: the legislative, the executive, and the judicial. And no persons charged with the exercise of powers properly belonging to one of these departments shall exercise any functions appertaining to either of the others, except in the cases expressly directed or permitted in this Constitution. Number 2. If the legislature authorizes the adoption of the regulations by an executive agency which bind persons outside the agency, the legislature may provide by law for a. Review of these regulations by a legislative agency before their effective date to determine initially whether each is within the statutory authority of its adoption. B. The suspension by a legislative agency of any such regulation which appears to exceed that authority until it is reviewed by a legislative body composed of members of the Senate and Assembly, which is authorized to act on behalf of both houses of the legislature. And C. The nullification of any such regulation by a majority vote of that legislative body, whether or not the regulation was suspended. Article 4. The Legislative Department. Section 1. Legislative power vested in a Senate and Assembly. The legislative authority of the state shall be vested in a Senate and Assembly which shall be designated the legislature of the state of Nevada, and the sessions of such legislature shall be held at the seat of government of the state. Section 2. Biennial sessions of legislature. Commencement, limitation on duration, void actions, submission of proposed executive budget. The sessions of the legislature shall be biennial and shall commence on the first Monday of February following the election of the members of the Assembly, unless the government of the state or the members of the legislature shall, in the interim, convene the legislature by proclamation or petition. Number 2. The legislature shall adjourn sine each regular session no later than midnight Pacific time at the end of the 120th consecutive calendar day of that session, inclusive of the day on which that session commences. Any legislative action taken after midnight Pacific time at the end of the 120th consecutive calendar day of that session is void, unless the legislative action is conducted during a special session. Number 3. The governor shall submit the proposed executive budget to the legislature not later than 14 calendar days before the commencement of each regular session. Number 4. For the purposes of this section, midnight Pacific time must be determined based on the actual measure of time that, on a final calendar day of the session, is being used and observed by the general population as the uniform time for the portion of Nevada which lies within the Pacific time zone, or any legal successor to the Pacific time zone, and which includes the seat of government of the state as designated by Section 1 of Article 15 of this Constitution. The legislature and its members, officers, and employees shall not employ any device, pretense, or fiction that adjusts, evades, or ignores this measure of time for the purpose of extending the duration of the session. Section 2A. Special sessions of legislature. Procedure for convening, precedents, limitations on business, and duration, and void actions. The legislature may be convened on extraordinary occasions upon a petition signed by 2/3 of the members elected to each house of legislature. A petition must specify the business to be transacted during the special session, indicate the date on or before which the legislature is to convene, and be transmitted to the Secretary of State. Upon receipt of one or more substantially similar petitions signed in the aggregate by the required number of members, calling for a special session, the Secretary of State shall notify all members of the legislature and the governor that a special session will be convened pursuant to this section. Number 2, at a special session convened pursuant to this section, the legislature shall not introduce, consider, or pass any bills except those related to the business specified in the petition and those necessary to provide for the expenses of the session. Number 3, a special session convened pursuant to this section takes precedence over a special session convened by the governor pursuant to Section 9 of Article 5 of this Constitution, unless otherwise provided in the petition convening the special session pursuant to this section. Number 4, the legislature may provide by law for the procedure of convening a special session pursuant to this section. Number 5, except as otherwise provided in this subsection, the legislature shall adjourn sine a special session convened pursuant to this section not later than midnight Pacific time at the end of the 20th consecutive calendar day of that session, inclusive of the day on which the session commences. Any legislative action taken after midnight Pacific time at the end of the 20th consecutive calendar day of that session is void. This subsection does not apply to the special session that is convened to conduct proceedings therefore. A. Impeachment or removal from office of the governor and other state and judicial officers pursuant to Article 7 of this Constitution. Or B. Expulsion from office of a member of the legislature pursuant to Section 6 of Article 4 of this Constitution. Number 6. For the purposes of this section, midnight Pacific time must be determined based on the actual measure of time that, on the final calendar day of this session, is being used and observed by the general population as the uniform time for the portion of Nevada which lies within the Pacific time zone, or any legal successor to the Pacific time zone, and which includes the seat of government of this state as designated by Section 1 of Article 15 of this Constitution. The legislature and its members, officers, and employees shall not employ any device, pretense, or fiction that adjusts, evades, or ignores this measure of time for the purpose of extending the duration of this session. Section 3. Members of Assembly. Election and term of office, eligibility for office. Number 1. The members of the Assembly shall be chosen biannually by the qualified electors of their respective districts on the Tuesday next after the first Monday in November, and their term of office shall be 2 years from the day next after their election. Number 2. No person may be elected or appointed as a member of the Assembly who has served in that office or at the expiration of his current term, if he is so serving, will have served 12 or more years from any district of this state. Section 4. Senators' election and term of office, eligibility for office. Number 1. Senators shall be chosen at the same time and places as members of the Assembly by the qualified electors of the respective districts, and their term of office shall be 4 years from the day next after their election. Number 2. No person may be elected or appointed as a senator who has served in that office or at the expiration of his current term, if he is so serving will have served 12 years or more from any district of this state. Section 5. Number of senators and members of Assembly. Apportionment. Senators and members of the Assembly shall be duly qualified electors in the respective counties and districts which they represent, and the number of senators shall not be less than 1/3 nor more than 1/2 of that of the members of the Assembly. It shall be the mandatory duty of the legislature at its first session after the taking of the decennial census of the United States in the year 1950, and after each subsequent decennial census, to fix by law the number of senators and assemblymen and apportion them among the several counties of the state, or among legislative districts, which may be established by law according to the number of inhabitants in them respectively. Section 6. Power of Houses to judge qualifications, elections, and returns of members, selections of officers, ruling of proceedings, and punishment of members. Each House shall judge of the qualifications, elections, and returns of its own members, choose its own officers, except the President of the Senate, determine the rules of its proceedings, and may punish its members for disorderly conduct, and with the concurrence of 2/3 of all the members elected, expel a member. Section 7. Punishment of a non-member. Either House, during the session, may punish by imprisonment any person not a member who shall have been guilty of disrespect to the House of disorderly or contemptuous behavior in its presence, but such imprisonment shall not extend beyond the final adjournment of the session. Section 8. Senators and members of assembly ineligible for certain offices. No senator or member of assembly shall, during the term for which he shall have been elected, nor for 1 year thereafter, be appointed to any civil office of profit under this state which shall have been created, or the emoluments of which shall have been increased during such term, except such office as may be filed by elections by the people. Section 9. Federal officers ineligible for state office. Exceptions. No person holding a lucrative office under the government of the United States or any other power shall be eligible to any civil office of profit under this state, provided that the postmasters whose compensation does not exceed $500 per annum or commissioners of deeds shall not be deemed as holding a lucrative office. Section 10. Embezzler of the public money ineligible for office, disqualification for bribery. Any person who shall be convicted of embezzlement or defalcation of the public funds of this state, or who may be convicted of having given or offered a bribe to procure his election, or the appointment to office, or received a bribe to aid in the procurement of office for any other person, shall be disqualified from holding any office of profit or trust in this state, and the legislature shall, as soon as practicable, provide by law for the punishment of such defalcation, bribery, or embezzlement as a felony. Section 11. Privileges of members. Freedom of arrest on civil process. Members of the legislature shall be privileged from arrest on civil process during the session of legislature and for 15 days next before the commencement of each session. Section 12. Vacancy. In the case of death or resignation of any member of the legislature, either senator or assemblyman, the county commissioners of the county for which such member was elected shall appoint a person of the same political party as a party for which elected such senator or assemblyman to fill such vacancy, provided that this section shall apply only in cases where no biennial election or any regular election at which county officers are to be elected takes place between the time of such death or resignation and the next succeeding session of the legislature. Section 13. Quorum, compelling attendance. A majority of all the members elected to each house shall constitute a quorum to transact business, but a smaller number may adjourn from day to day and may compel the attendance of absent members in such manner and under the such penalties as each house may prescribe. Section 14. Journal. Each house shall keep a journal of its own proceedings, which shall be published, and the yeas and nays of the members of either house on any question shall, at the desire of any 3 members of present, be entered on the journal. Section 15. Open sessions and meetings. Adjournment for more than 3 days or to another place. The doors of each house shall be kept open during its session, and neither shall be without the consent of the other. Adjourn for more than 3 days, nor to any other place that which they may be holding their sessions. These meetings of all legislative committees must be open to the public, except meetings held to consider the character, alleged misconduct, professional competence, or physical or mental health of a person. Section 16. Bills may originate in either house an amendment. Any bill may originate in either house of legislature, and all bills passed by one may be amended in the other. Section 17. Act to embrace on subject only, title, and amendment. Each law enacted by the legislature shall embrace but one subject and matter properly connected therewith, which subject shall be briefly expressed in the title, and no law shall be revised or amended by reference to its title only, but in such case the act as revised or section as amended shall be reenacted and published at length. Section 18. Reading of bill. Voting on final passage and number of members necessary to pass a bill or joint resolution, signatures and referral of certain measures to voters, and consent of calendar. Number 1. Every bill except a bill placed on consent calendar adopted as provided in subsection 4 must be read by sections on all 3 several days. In each house, unless in case of emergency 2/3 of the house where such bill is pending shall deem it expedient to dispense with this rule. The reading of a bill by sections on its final passage shall in no case be dispensed with. The vote on the final passage of every bill or joint resolution shall be taken by yeas and nays to be entered on the journals of each house. Except as otherwise provided in the subsection 2, a majority of all the members elected to each house is necessary to pass every bill or joint resolution, and all bills or joint resolutions so passed shall be signed by the preceding officers of the representative houses and by the Secretary of Senate and the Clerk of the Assembly. Number 2, except as otherwise provided in subsection 3, an affirmation vote of not fewer than 2/3 of the members elected to each house is necessary to pass a bill or joint resolution which creates, generates, or increases any public revenue in any form, including but not limited to taxes, fees, assessments, and rates, or changes in the computation basis of taxes, fees, and assessments and rates. Number 3, a majority of all the members elected to each house may refer any measure which creates, generates, or increases any revenue in any form to the people of the state at the next general election, and shall become effective and enforced only if it has been approved by a majority of the votes cast on the measure at such election. Number 4, each house may provide by rule for the creation of a consent calendar and establish the procedure for the passage of uncontested bills. Section 19. Manner of drawing money from Treasury. No money shall be drawn from the Treasury but in consequence of appropriations made by law. Section 20. Certain local and special laws prohibited. The legislature shall not pass local or special laws in any of the following enumerated cases, that is to say, regulating the jurisdictions and duties of justices of the peace and of the constables and fixing their compensation. For the punishment of crimes and misdemeanors, regulating the practice of courts of justice, providing for changing the venue in civil and criminal cases, granting divorces, changing the names of persons, vacating roads, town plots, streets, alleys, and public squares, summoning and impaling grand and petite juries and providing for their compensation, regulating county and township businesses, regulating the election of county and township officers, for the assessment and collection of taxes for state, county, and township purposes, providing for opening and conducting elections of the state, county, and township officers, and designating the places of voting, providing for the sale of real estate belonging to minors or other persons laboring under legal disabilities, giving effect to invalid deeds, wills, or other instruments, and refunding money paid into the state treasury or into the treasury of any county, releasing the indebtedness, liability, or obligation of any corporation, association, or person to the state, or to any county, town, or city of this state by nothing in this section by being construed to deny or restrict the power of the legislature to establish and regulate the compensation and fees of county officers, to authorize and empower the boards of county commissioners of the various counties of the state to establish and regulate the compensation and fees of township officers in the respective counties, to establish and regulate the rates of freight, passage, toll, and charges of railroads, toll roads, ditch, flume, and tunnel companies incorporated under the laws of this state or doing business therein. Section 21. General laws to have uniform application. In all cases enumerated in the preceding section, and all other cases where a general law can be made applicable, all laws shall be general and of uniform operation throughout the state. Section 22. Suit against the state. Provision may be made by general law for bringing suit against the state as to all liabilities originating after the adoption of this Constitution. Section 23. Enacting clause. Law to be enacted by bill. The enacting clause of every law shall be as follows. The people of the state of Nevada, represented in the Senate and Assembly, do enact as follows, and no law shall be enacted except by bill. Section 24. Lotteries. Except as otherwise provided in subsection 2, no lottery may be authorized by this state, nor may lottery tickets be sold. The state and political subdivisions thereof shall not operate a lottery. The legislature may authorize persons engaged in charitable activities or activities not for profit to operate a lottery in the form of a raffle or drawing on their own behalf. All proceeds of the lottery, less expenses directly related to the operation of the lottery, must be used only to the benefit charitable or nonprofit activities in this state. A charitable or nonprofit organization shall not employ or otherwise engage any person to organize or operate its lottery for compensation. The legislature may provide by law for the regulation of such lotteries. Section 25. Uniform county and township government. The legislature shall establish a system of county and township governments which shall be uniform throughout the state. Section 26. Boards of county commissioners. Election and duties. The legislature shall provide by law for the election of a board or county commissioner in each county, and such county commissioner shall jointly and individually perform such duties as may be prescribed by law. Section 27. Disqualification of jurors and elections. Law shall be made to exclude from serving on juries all persons not qualified electors of this state, and all persons who shall have been convicted of bribery, perjury, forgery, larceny, and other high crimes, unless restored to civil rights, and laws shall be passed regulating elections and prohibiting under adequate penalties all undue influence thereon from power, bribery, tumult, or other improper practice. Section 28. Compensation of legislative officers and employees. Increase or decrease in compensation. No money shall be drawn from the state treasury as salary or compensation to any officer or employee of the legislature or either branch thereof, except in cases wherein such salary or compensation has been fixed by law in force prior to the election or appointment of such officer or employee. And the salary or compensation so fixed shall neither be increased nor diminished so as to apply to any officer or employee of the legislature or any other branch thereof at such session, provided that the restriction shall not apply to the first session of the legislature. Section 29. Duration of regular and special sessions. This was repealed in 1958. Section 30. Homesteads, exemption from forced sale, joint consent required for alienation, recording of declaration. A homestead, as provided by law, shall be exempt from forced sale under any process of law and shall not be alienated without the joint consent of husband and wife when the relation exists. But no property shall be exempt from sale or taxes or for the payment of obligations contracted for the purposes of said premises, or for the erection of improvements thereon, provided the provisions of the section shall not apply to any process of law obtained by virtue of lien given by the consent of both husband and wife, and law shall be enacted providing for the recording of such homestead within the county in which the same shall be situated. Section 31. Property of married persons. All property, both real and personal, of a married person owned or claimed by such person before marriage, and the acquainted afterward by gift, devise, or descent shall be the separate property of such person. The legislature shall more clearly define the rights of married persons in relation to their separate property and other property. Section 32. County officers, power of legislature, election, duties and compensations, and duties of the clerks. The legislature shall have power to increase, diminish, and consolidate or abolish the following county officers: county clerks, county recorders, auditors, sheriffs, district attorneys, and public administrators. The legislature shall provide for their election by the people and fix by law their duties and compensation. County clerks shall be ex officio clerks of the courts of record and of the boards of county commissioners in and for the respective counties. Section 33. Compensation of members of legislature, payment of postage, stationery, and other expenses, and additional allowances for officers. The members of the legislature shall receive for their services a compensation to be fixed by law and paid out to the public treasury for not to exceed 60 days during any regular session of legislature and not to exceed 20 days during any special session, but no increase of such compensation shall take effect during the term for which the members of the either house shall have been elected, provided that an appropriation may be made for the payment of such actual expenses as members of their legislature may incur for postage, express charges, newspapers, and stationery, not exceeding the sum of $60 for any general or special session to each member. And furthermore provided, the Speaker of the Assembly and Lieutenant Governor, as President of the Senate, shall each, during the time of their actual attendance as such presiding officers, receive an additional allowance of $2 per diem. Section 34. Election of the United States Senators. This section was repealed in 2004. Section 35. Bills to be presented to governor approval, disapproval, and reconsideration by legislature, failure of governor to return bill. Every bill which may have passed the legislature shall, before it becomes a law, be presented to the governor. If he approved it, he shall sign it, but if not, he shall return it with his objections to the house in which it originated, which house shall cause such objections to be entered upon its journal, and proceed to reconsider it. If after such reconsideration is again passed both houses by yeas and nays, by a vote of 2/3 of the members elected to each house, it shall become a law, notwithstanding the governor's objections. If any bill shall not be returned within 5 days after it shall have been presented to him, Sunday excepted, exclusive of the day on which he received, the same shall be a law, in like manner as if he had signed it, unless the legislature by its final adjournment prevent such return, in which case it shall be law, unless the governor within 10 days next after the adjournment, Sundays excepted, shall file such bill with his objections thereto, in the office of Secretary of State, who shall by the same before the legislation at the next session, in like manner as if it had been returned by the governor, and if the same shall receive the vote of 2/3 of the members elected to each branch of legislature, upon the vote taken by yeas and nays to be entered upon the journals of each house, it shall become a law. Section 36. Abolishment of county, approval of voters in county. The legislature shall not abolish any county unless the qualified voters of the county affected shall, at a general or special election, first approve such proposed abolishment by a majority of all the voters voting in such election. The legislature shall provide, by law, the method of initiating and conducting such election. Section 37. Continuity of government in cases of enemy attack, succession to public officers, legislative quorum requirements, and relocation of seat of government. The legislature, in order to ensure continuity of state and local government operations in periods of emergency resulting from disasters caused by enemy attack, shall have the power and the immediate duty to provide for immediate and temporary succession to the powers and duties of public offices, of whatever nature and whether filled by election or appointment, the incumbents of which may become unavailable for carrying on the powers and duties of such offices, and to adopt such measures as may be necessary and proper for ensuring the continuity of governmental operations, including changes in quorum, requirements, and legislature, and the relocation of the seat of government. In the exercise of the powers hereby conferred, the legislature shall conform to the requirements of this Constitution, except to the extent that in the judgment of the legislature so to do would be impracticable or would admit an undue delay. Section 37A. Consolidation of city and county containing seat of government into one municipal government, separating taxing districts. Notwithstanding the general provisions of the Section 20, 25, 26, and 36 of this article, the legislature may by law consolidate into one municipal government with one set of officers, the city designated at the seat of the government of the state, and the county in which such city is situated. Such consolidated municipality shall be considered as a county for the purpose of representation in the legislature, and shall have all the powers conferred upon counties by this Constitution or by general law, and shall have such other powers as may be conferred by its charter. Notwithstanding the general provisions of the Section 1 of Article 10, the legislature may create two or more separate taxing districts within such consolidated municipality. Section 38. The use of plant genus cannabis for medical purposes. Number 1. The legislature shall provide by law for A. The use by a patient upon the advice of his physician of the plant of genus cannabis for the treatment of alleviation of cancer, glaucoma, acquired immunodeficiency syndrome, severe persistent nausea, akaxemia resulting from these or other chronic or debilitating medical conditions, epilepsy and other disorders characterized by seizure, multiple sclerosis, and other disorders characterized by muscular spasticity, or other conditions approved pursuant to the law of such treatment. B. Restriction of the medical use of the plant by a minor to require diagnosis and written authorization by a physician, parental consent, and parental control of the acquisition and use of the plant. C. Protection of the plant and property related to the use from forfeited except upon conviction or plea of guilty or nolo contendere for possession or use not authorized by or pursuant to this section. D. A registry of patients and their attendants who are authorized to use the plant for a medical purpose, to which law enforcement officers may resort to verify a claim or authorization and which is otherwise confidential. E. Authorization of appropriate methods for supply of the plant to patients authorized to use it. Number 2. This section does not A. Authorize the use or possession of the plant for a purpose other than medical or use for a medical purpose in public. B. Require the reimbursement by an insurer for medical use of the plant or accommodation of medical use in a place of employment. Article 5. Executive Department. Section 1. Supreme executive power vested in governor. The supreme executive power of this state shall be vested in a chief magistrate who shall be governor of the state of Nevada. Section 2. Election and term of governor. The governor shall be elected by the qualified electors at the time and places of voting for members of the legislature and shall hold his office for 4 years from the time of his installation and until his successor has been qualified. Section 3. Eligibility, qualifications, and number of terms. No person shall be eligible to the office of governor who is not qualified elector and who, at the time of such election, has not attained the age of 25 years, and who shall not have been a citizen resident of this state for 2 years next preceding the election. Nor shall any person be elected to the office of governor for more than twice, and no person who has held the office of governor or acted as governor for more than 2 years of a term to which some other person was elected governor shall be elected to the office of governor more than once. Section 4. Returns of general election transmitted to Secretary of State, canvassed by Supreme Court, and declaration of election. The returns of every election for the United States Senator and Member of Congress, district and state officers, and for and against questions submitted to the electors of the state of Nevada, voted for at the general election shall be sealed up and transmitted to the seat of government, directed to the Secretary of State and the Chief Justice of the Supreme Court, and to the Associate Justices, or a majority thereof, shall meet at the office of Secretary of State on a day to be fixed by law, and open and canvass the election returns for the United States Senator and members of Congress, district and state officers, and for and against any questions submitted to the electors of the state of Nevada, and forthwith declare the result and to publish the names of persons elected and the results of the vote cast upon any questions submitted to the electors of the state of Nevada. The persons having the highest number of votes for the representative office shall be declared elected, but in a case any two or more have an equal and the highest number of votes for the same office, the legislature shall, by joint vote of both houses, elect one said person to fill said office. Section 5. Governor is Commander-in-Chief of State Military Forces. The governor shall be Commander-in-Chief of the military forces of the state, except when they shall be called into the service of the United States. Section 6. Transaction of executive businesses, reports of executive officers. He shall transact all executive business with the officers of the government, civil and military, and may require information in writing from the officers of the executive department upon any subject relating to the duties of their respective offices. Section 7. Responsibility for execution of laws. He shall see that the laws are faithfully executed. Section 8. Vacancies filled by governor. When any office shall, for any cause, become vacant, and no mode is provided by the Constitution and laws for filling such a vacancy, the governor shall have the power to fill such vacancy by granting a commission which shall expire at the next election and the qualification of the person elected to such office. Section 9. Special sessions of legislature, authority of the governor, limitations on business, and duration, and void actions. Number 1. Except as otherwise provided in Section 2A of Article 4 of this Constitution, the governor may, on extraordinary occasions, convene the legislature by proclamation, and shall state to both houses, when organized, the business for which they have been specially convened. Number 2. At a special session convened pursuant to this section, the legislature shall not introduce, consider, or pass any bills except those related to the business for which a legislature has been specially convened and those necessary to provide for the expenses of the session. Number 3. Except as otherwise provided in this subsection, the legislature shall adjourn sine die a special session convened pursuant to this section not later than midnight Pacific time, at the end of the 20th consecutive calendar day of that session, inclusive of the day on which that session commences. Any legislative action taken after midnight Pacific time at the end of the 20th consecutive calendar day of that session is void. This subsection does not apply to a special session that is convened to conduct proceedings for A. Impeachment or removal from the office of the governor and the other state and judicial officers pursuant to Article 7 of this Constitution, or B. Expulsion from office of a member of the legislature pursuant to Section 6 of Article 4 of this Constitution. Number 4. For the purposes of this section, midnight Pacific time must be determined based on the actual measure of that time, on the final calendar day of the session, is being used and observed by the general population as the uniform time for the portion of Nevada which lies within the Pacific time zone, or any legal successor to the Pacific time zone, and which includes the seat of government of this state as designated by the Section 1 of Article 15 of this Constitution. The legislature and its members, officers, and employees shall not employ any device, pretense, or fiction that adjusts, evades, or ignores this measure of time for the purpose of extending the duration of the session. Section 10. Governor's Message. He shall communicate by message to the legislature at every regular session that condition of the state and recommend such measures as he may deem expedient. Section 11. Adjournment of legislature by governor. In case of a disagreement between the two houses with respect to the time of adjournment, the governor shall have power to adjourn the legislature to such times as he may think proper, provided it not beyond the time fixed for the meeting of the next legislature. Section 12. Person holding federal office and eligible for office of governor. No person shall, while holding any office under the United States government, hold the office of governor except as herein expressly provided. Section 13. Pardons, reprieves, commutations of sentence, remission of fines, and forfeitures. The governor shall have the power to suspend the collection of fines and forfeitures and grant reprieves for a period not exceeding 60 days, dating from the time of conviction, for all offenses except in cases of impeachment. Upon conviction for treason, he shall have power to suspend the execution of the sentence until the case shall be reported to the legislature at its next meeting, when the legislature shall either pardon, direct the execution of the sentence, or grant a further reprieve. And if the legislature shall fail or refuse to make the final disposition of such a case, the sentence shall be enforced at such time and place as the governor by his order may direct. The governor shall communicate to the legislature, at the beginning of every session, every case of fine or forfeiture remitted, or reprieve, pardon, or commutation granted, stating the names of the convict, the crime for which he was convicted, the sentence, its date, and the date of remission, commutation, pardon, or reprieve. Section 14A. Remission of fines and forfeitures, commutations and pardons, suspension of sentence, and probation. Number 1. The governor, justices of the Supreme Court, an attorney general, or a major part of them, of whom the governor shall be one, may upon such conditions and with such limitations and restrictions as they may think proper, remit fines and forfeitures, commute punishments, except as provided in subsection 2, and grant pardons after convictions in all cases, except treason and impeachments, subject to such regulations as may be provided by law relative to the manner of applying for pardons. Number 2. Except may be provided by law, a sentence of death or a sentence of life imprisonment without the possibility of parole may not be commuted to a sentence which would allow parole. Number 3. The legislature is authorized to pass laws conferring upon the district courts authority to suspend the execution of sentences, fix the conditions for, and to grant probation, and within the minimum and maximum periods authorized by law, fix the sentence to be served by the person convicted of crime in said courts. Section 14B. State Board of Pardons Commissioners, remission of fines and forfeitures, commutations and pardons, suspension of sentence, probation. Number 1. The governor, justice of the Supreme Court, and attorney general shall constitute the State Board of Pardons Commissioners. Number 2. The State Board of Pardons Commissioners may, upon such conditions and with such limitations and restrictions as they may think proper, remit fines and forfeitures, commute punishments, except as provided in subsection 3, and grant pardons after convictions in all cases except treason and impeachments, subject to such regulations as may be provided by law relative to the manner of applying for pardons. Number 3. Except as may be provided by law, a sentence of death or a sentence of life imprisonment without the possibility of parole may not be commuted to a sentence which would allow parole. Number 4. The State Board of Pardons Commissioners shall meet at least quarterly. Number 5. Any member of the State Board of Pardons Commissioners may submit matters of consideration by the State Board of Pardons Commissioners. Number 6. A majority of the members of the State Board of Pardons Commissioners is sufficient for any action taken by the State Board of Pardons Commissioners. Number 7. The legislature is authorized to pass laws conferring upon the district courts authority to suspend the execution of sentences, fix the conditions for, and to grant probation, and within the minimum and maximum periods authorized by law, fix the sentence to be served by the person convicted of a crime in said courts. Section 15. The Great Seal. There shall be a seal of this state, which shall be kept by the governor and used by him officially, and shall be called the Great Seal of the State of Nevada. Section 16. Grants and commissions, signatures, and seal. All grants and commissions shall be in the name and by the authority of the State of Nevada, sealed with the Great Seal of the State, signed by the governor and countersigned by the Secretary of State. Section 17. Election, term, qualifications and duties of Lieutenant Governor, President of the Senate, President pro tem of Senate to act as governor in certain circumstances. A lieutenant governor shall be elected at the same time and places and in the same manner as the governor and in his term, and his eligibility shall also be the same. He shall be President of the Senate, but shall only have casting vote therein. If during a vacancy of the office of governor, the lieutenant governor shall be impeached, displaced, resign, die, or become incapable of performing the duties of the office, or be absent from the state, the President pro tem of the Senate shall act as governor until the vacancy be filled or the disability cease. Section 18. Vacancy in office of governor, duties to devolve upon lieutenant governor. In cases of the impeachment of the governor, or his removal from office, death, inability to discharge the duties of said office, resignation, or absent from the state, the powers and duties of the office shall devolve upon the lieutenant governor for the residue of the term, or until the disability shall cease. But when the governor shall, with the consent of the legislature, be out of state in time of war, and at the head of any military force thereof, he shall continue commander-in-chief of the military forces of the state. Section 19. Other state officers, election and term of office, and eligibility for office. Number 1. A Secretary of State, a Treasurer, a Controller, and an Attorney General shall be elected at the same time and places, and in the same manner as the governor. The term of office of each shall be the same as prescribed for the governor. Number 2. Any elector shall be eligible to any of these offices, but no person may be elected to any of them more than twice, or more than once if he has previously held the office by election or appointment. Section 20. Secretary of State, duties. The Secretary of State shall keep a true record of the official acts of the legislative and executive departments of the government, and shall, when required, lay the same in all matters relative thereto before either branch of the legislature. Section 21. Board of State Prison Commissioners, Board of Examiners, and Examination of Claims. The Governor, Secretary of State, and Attorney General shall constitute a Board of State Prison Commissioners, which board shall have such supervision of all matters connected with the state prison as may be provided by law. They shall also constitute a Board of Examiners, with powers to examine all claims against the state except salaries or compensation of officers fixed by law, and perform such other duties as may be prescribed by law, and no claim against the state, except salaries or compensation of officers fixed by law, shall be passed upon the legislature without having been considered and acted upon by said Board of Examiners. Section 22. Duties of certain state officers. The Secretary of State, the State Treasurer, State Controller, Attorney General, and the Superintendent of Public Instruction shall perform such other duties as may be prescribed by law. Article 6. Judicial Department. Section 1. Judicial power vested in court system. The judicial power of this state is vested in a court system comprising of a Supreme Court, a Court of Appeals, district courts, and justices of the peace. The legislature may also establish, as part of the system, courts for municipal purposes only in incorporated cities and towns. Section 2. Supreme Court. Composition, staggered terms of justices, holding of court by panels of justices, and full court. Number 1. The Supreme Court consists of Chief Justice and 2 or more Associate Justices and may be provided by law. And increasing or diminishing the number of Associate Justices, the legislature shall provide for the arrangement of the terms so that an equal number of terms, as nearly as may be, expire every 2 years. Number 2. The legislature may provide by law, A. If the court consists of more than 5 justices, for the hearing and decision of cases by panels of no fewer than 3 justices, the resolution by the full court of any conflicts between decisions so rendered, and the kinds of cases which must be heard by the full court. B. For the places of holding court by panels of justices is established and by the full court. Section 3. Justices of Supreme Court, election, terms, Chief Justice. The justices of the Supreme Court shall be elected by qualified electors of the state at the general election, and shall hold office for the term of 6 years from and including the first Monday of January next preceding their election, provided that there shall be elected, and the first election under this Constitution, 3 justices of the Supreme Court who shall hold office from and including the first Monday of December A.D. 1864, and continue in office thereafter, 2, 4, and 6 years respectively, from and including the first Monday of January next succeeding their election. They shall meet as soon as practicable after their election and qualification, and at their first meeting shall determine by lot the term of office each shall fill, and the justice drawing the shortest term shall be Chief Justice. And after the expiration of his term, the one having the next shortest term shall be Chief Justice, after which the senior justice in commission shall be Chief Justice. And in case the commission of any 2 or more of said justices shall bear the same date, they shall determine by lot who shall be Chief Justice. Section 3A. Court of Appeals. Composition, panel of judges, appointment, election in terms of judges, chief judge, service of judges as supplemental district judges. Number 1. The Court of Appeals consists of 3 judges or such greater number as the legislature may provide by law. If the number of judges is so increased, the Supreme Court must provide by rule for the assignment of each appeal to a panel of 3 judges for decision. Number 2. After the initial terms, each judge of the Court of Appeals must be elected by the qualified electors of the state at the general election for a term of 6 years beginning on the first Monday of January next after the election. The initial 3 judges of the Court of Appeals must be appointed by the governor from among 3 nominees selected for each individual seat by the Permanent Commission on Judicial Selection described in subsection 3 of section 20 of this article. After the expiration of 30 days from the date on which this Permanent Commission on Judicial Selection has been delivered to the governor, its list of nominees for the initial judges. If the governor has not made the appointments required by this section, the governor shall make no other appointment to any public office until the governor has appointed a judge from the list submitted. The term of the initial judges is 2 years beginning on the first Monday of January, next after the election date of this section, and an initial judge may succeed himself. If there is an increase in the number of judges, each additional judge must be elected by the qualified electors of this state at the first general election following the increase for a term of 6 years beginning on the first Monday of January next after the election. Number 3. The Chief Justice of the Supreme Court shall appoint one of the judges of the Court of Appeals to be Chief Judge. The Chief Judge serves a minimum term of 4 years, except that the term of the initial Chief Judge is 2 years. The Chief Judge may succeed himself. The Chief Judge may resign the position of the Chief Judge without resigning from the Court of Appeals. Number 4. The Supreme Court shall provide by rule for the assignment of 1 or more judges of the Court of Appeals to devote a part of their time to serve as supplemental district judges where needed. Section 4. Jurisdiction of Supreme Court and Court of Appeals. Appointment of judge to sit for disabled or disqualified justice or judge. Number 1. The Supreme Court and the Court of Appeals have appellate jurisdiction in all civil cases arising in district courts, and also on questions of law alone in all criminal cases in which the offense charged is within the original jurisdiction of the district courts. The Supreme Court shall fix by rule the jurisdiction of the Court of Appeals and shall provide for the review, where appropriate, of appeals decided by the Court of Appeals. The Supreme Court and the Court of Appeals have power to issue writs of mandamus, certiorari, prohibition, quo warranto, and habeas corpus, and also all writs necessary or proper to complete the exercise of their jurisdiction. Each justice of the Supreme Court and judge of the Court of Appeals may issue writs of habeas corpus to any part of the state upon petition by or on behalf of any person held in actual custody in the state, and may make such writs returnable before the issuing justice or judge the justice or judge is a member, or before any district court in the state or any judge of the district court. Number 2, in the case of disability or disqualification for any cause of a justice of the Supreme Court, the governor may designate a judge of the Court of Appeals or a district judge to sit in the place of the disqualified or disabled justice. Section 5. Judicial Districts, Election, Terms of District Judges. The state is hereby divided into 9 judicial districts, of which the county of Story shall constitute the first, the county of Ormsby the second, the county of Lyon the third, the county of Washoe the fourth, the counties of Nye and Churchill the fifth, the county of Humboldt the sixth, the county of Lander the seventh, the county of Douglas the eighth, and the county of Esmeralda the ninth. The county of Roop shall be attached to the county of Washoe for judicial purposes until otherwise provided by law. The legislature may, however, provide by law for an alteration in the boundaries or divisions of the districts herein prescribed, and also for increasing or diminishing the number of judicial districts and judges therein. But no such change shall take effect except in the case of a vacancy or the expiration of the term of an incumbent of the office. In the first general election under this Constitution, there shall be elected in each of the representative districts, except as in the section hereof otherwise provided, 1 district judge who shall hold office from and including the first Monday of December A.D. 1864 and until the first Monday of January in the year 1867. After the said first election, there shall be elected at the general election, which immediately precedes the expiration of the term of the predecessor, 1 district judge in each of the respective judicial district, except in the first district as in this section hereafter provided. The district judges shall be elected by qualified electors of the respective districts and shall hold office for the term of 6 years, expecting those elected at said first election from and including the first Monday of January, next succeeding their election and qualification, provided that the first judicial district shall be entitled to and shall have 3 district judges who shall process coextensive and concurrent jurisdiction, and who shall be elected at the same times in the same manner and shall not hold office for the like terms as herein prescribed. In relation to the judges in other judicial districts, any one of the said judges may preside on the impaneling of grand juries and the presentment and trial on indictments under such rules and regulations as prescribed by law. Section 6. District Courts. Jurisdiction, Referees, and Family Court. Number 1. The district courts in several judicial districts of the state have original jurisdiction in all cases excluded by law from the original jurisdiction of justices' courts. They also have final appellate jurisdiction in cases arising in justices' courts, as such in inferior tribunals as may be established by law. The district courts and the judges thereof have power to issue writs of mandamus, prohibition, and injunction, quo warranto, certiorari, and other writs proper and necessary for the complete exercise of their jurisdiction. The district courts and the judges thereof shall also have power to issue writs of habeas corpus on petition by or on the behalf of any person who is held in actual custody in the respective districts, or who has suffered a criminal conviction in the respective districts and has not completed the sentence imposed pursuant to the judgment of conviction. Number 2, the legislature may provide by law for A. Referees in district courts. B. The establishment of a family court as a division of any district court and may prescribe its jurisdiction. Section 7. Terms of courts. The times of holding the Supreme Court, the Court of Appeals, and the district courts must be as fixed by law. The terms of the Supreme Court must be held at the seat of government unless the legislature otherwise provides by law, except the Supreme Court may hear oral argument at other places in the state. The terms of the Court of Appeals must be held at the place provided by law. The terms of the district courts must be held at the county seats of the respective counties unless the legislature otherwise provides by law. Section 8. Number, qualifications, terms of office, and jurisdictions of justices of the peace, appeals, and courts of record. Number 1. The legislature shall determine the number of justices of the peace to be elected in each city and township of the state and shall fix by law their qualifications, their terms of office, and the limits of their civil and criminal jurisdiction, according to the amount in controversy, the nature of the case, the penalty provided, or any combination of these. Number 2. The provisions of this section affecting the number, qualifications, terms of office, and jurisdiction of justices of the peace become effective on the first Monday of January 1979. Number 3. The legislature shall also prescribe by law the manner and determine the cases in which appeals may be taken from justices and other courts. The Supreme Court, the Court of Appeals, the district courts, and other such courts as the legislature designates are courts of record. Section 9. Municipal courts. Provision shall be made by law prescribing the powers, duties, and responsibilities of any municipal court that may be established in the pursuance of Section 1 of this article, and also fixing by law the jurisdiction of said court as to not conflict with that of the several courts of record. Section 10. Fees or perquisites of judicial officers. No judicial officer except justices of the peace and city recorder shall receive to his own use any fees or perquisites of office. Section 11. Justices and judges ineligible for other offices. The justice of the Supreme Court, the judge of a court of appeals, and the district judges are ineligible to any office other than a judicial office during the term for which they have been elected or appointed. All elections or appointments of any such judges by the people, legislature, or otherwise during said period to any office other than judicial are void. Section 12. Judge not to charge jury respecting matters of fact, statement of testimony, and declaration of law. Judges shall not charge juries in respect to the matters of fact, but may state the testimony and declare the law. Section 13. Style of process. The style of all process shall be the state of Nevada, and all prosecutions shall be conducted in the name and by the authority of the same. Section 14. One form of civil action. There shall be but one form of civil action, and law and equity may be administered in the same action. Section 15. Compensation of justices and judges. The justices of the Supreme Court, the judges of the Court of Appeals, and the district judges are each entitled to receive for their services a compensation to be fixed by law and paid in the manner provided by law, which must not be increased or diminished during the term of which they have been elected unless a vacancy occurs, in which case the successor of the former incumbent is entitled to receive only such salary as may be provided by law at the time of his election or appointment. A provision must be made by law for setting apart from each year's revenue a sufficient amount of money to pay such compensation. Section 16. Special fee in civil action for compensation of judges. The legislature, at the first session and from the time to time thereafter, shall provide by law that upon the institution of each civil action and other proceedings, and also upon the perfecting of an appeal in any in civil action or proceeding, in the civil courts of record in the state, a special court fee or tax shall be advanced to the clerks of said courts, respectively by the party or parties bringing such action or proceedings, or taking such appeal, and the money so paid in shall be accounted for by such clerks, and applied towards the payment of compensation of the judges of said courts as shall be directed by law. Section 17. Absence of judicial officer from state, vacation of office. The legislature shall have no power to grant leave of absence to a judicial officer, and any such officer who shall absent himself from the state for more than 90 consecutive days shall have been deemed to have vacated his office. Section 18. Territorial judicial officers not superseded until election and qualification of successors. No judicial officer shall be superseded, nor shall the organization of the several courts of the Territory of Nevada be changed until the election and qualification of the several officers provided for in this article. Section 19. Administration of a court system by Chief Justice. Number 1. The Chief Justice is the administrative head of the court system. Subject to such rules as the Supreme Court may adopt, the Chief Justice may A. Apportion the work of the Supreme Court among justices. B. Assign district judges to assist in other judicial districts or to specialized functions which may be established by law. C. Recall to active service any retired justice or judge of the court system who consents to such recall and who has not been removed or retired for cause or defeated for retention in office, and may assign him to appropriate temporary duty within the court system. Number 2. In the absence or temporary disability of the Chief Justice, the Associate Justice, senior in commission, shall act as Chief Justice. Number 3. This section becomes effective July 1st, 1977. Section 20. Filling of vacancies occurring before expiration of term of office in Supreme Court or Court of Appeals or among district judges. Commission on Judicial Selection. Number 1. When a vacancy occurs before the expiration of any term of office in the Supreme Court or the Court of Appeals or among the district judges, the governor shall appoint a justice or judge from among 3 nominees selected for such individual vacancy by the Commission on Judicial Selection. Number 2. The term of office of any justice or judge so appointed expires on the first Monday of January following the next general election. Number 3. Each nomination for the Supreme Court or the Court of Appeals must be made by the permanent commission composed of A. The Chief Justice or an Associate Justice designated by him. B. 3 members of the State Bar of Nevada, a public corporation created by statute, appointed by its Board of Governors, and C. 3 persons not members of the legal profession appointed by the governor. Number 4. Each nomination for the district court must be made by a temporary commission composed of A. The Permanent Commission. B. A member of the State Bar of Nevada, resident in the judicial district in which the vacancy occurs, appointed by the Board of Governors of the State Bar of Nevada, and C. A resident of such judicial district, not a member of the legal profession, appointed by the governor. Number 5. If at any time the State Bar of Nevada ceases to exist as a public corporation or ceases to include all attorneys admitted to practice before the courts of the state, the legislature shall provide by law, or if it fails to do so, the Supreme Court shall provide by rule, for the appointment of attorneys at law to the positions designated in this section to be occupied by members of the State Bar of Nevada. Number 6. The term of office of each appointive member of the Permanent Commission, except the first members, is 4 years. Each appointing authority shall appoint one of the members first appointed for a term of 2 years. If a vacancy occurs, the appointing authority shall fill the vacancy for the unexpired term. The additional members of a temporary commission must be appointed when a vacancy occurs, and their terms expire when the nominations for such vacancy have been transmitted to the governor. 7. An appointing authority shall not appoint to the permanent commission more than A. One resident from any county. B. 2 members of the same political party. C. No member of the Permanent Commission may be a member of the Commission on the Judicial Discipline. Number 8. After the expiration of 30 days from the date on which the Commission on Judicial Selection has delivered to him its list of nominees for any vacancy, if the governor has not made the appointment required by this section, he shall make no other appointment to any public office until he has appointed a justice or judge from the list submitted. Section 21. Commission on Judicial Discipline, Code of Judicial Conduct. Number 1. A justice of the Supreme Court, a judge of the Court of Appeals, a district judge, a justice of the peace, or a municipal judge may, in addition to the provision of Article 7 for impeachment, be censured, retired, removed, or otherwise disciplined by the Commission on Judicial Discipline, pursuant to the rules governing appeals adopted by the Supreme Court. A justice or judge may appeal from the action of the Commission to the Supreme Court, which may reverse such action or take any alternative action provided in this subsection. Number 2. The Commission is composed of A. 2 justices or judges appointed by the Supreme Court. B. 2 members of the State Bar of Nevada, a public corporation created by statute appointed by its Board of Governors, and 3 persons not members of the legal profession appointed by the governor. D. The Commission shall elect a chairman from among its 3 lay members. Number 3. If at any time the State Bar of Nevada ceases to exist as a public corporation or ceases to include all attorneys admitted to practice before the court of this state, the legislature shall provide by law, or if it fails to do so, the Supreme Court shall provide by rule for the appointment of attorneys at law to the positions designated in this section to be occupied by members of the State Bar of Nevada. Number 4. The term of office of each appointive member of the Commission, except the first member, is 4 years. Each appointing authority shall appoint one of the members first appointed for a term of 2 years. If a vacancy occurs, the appointing authority shall fill the vacancy for the unexpired term. An appointing authority shall not appoint more than 1 resident of any county. The governor shall not appoint more than 2 members of the same political party, and no member may be a member of a commission on the judicial selection. Number 5. The legislature shall establish A. In addition to censure, retirement and removal, other forms of disciplinary action that the Commission may impose. B. The grounds for censure and other disciplinary action that the Commission may impose, including but not limited to violations of the provisions of the Code of Judicial Conduct. C. The standards for the investigation of matters relating to the fitness of a justice or judge, and D. The confidentiality or non-confidentiality, as appropriate, of proceedings before the Commission, except that, in any event, a decision to censure, retire, or remove a justice or judge must be made public. Number 6. The Supreme Court shall adopt a Code of Judicial Conduct. Number 7, the Commission shall adopt rules of procedure for the conduct of its hearings and any other procedural rules it deems necessary to carry out its duties. 8. No justice or judge may by virtue of this section be A. Removed except for willful misconduct, willful or persistent failure to perform the duties of his office, or habitual intemperance, or B. Retired except for advanced age which interferes with the proper performance of his judicial duties, or for mental or physical disability which prevents the proper performance of his judicial duties and which is likely to be permanent in nature. Number 9, any matter relating to the fitness of a justice or a judge may be brought to the attention of the Commission by any person or on the motion of the Commission. The Commission shall, after preliminary investigation, dismiss the matter or order a hearing to be held before it. If a hearing is ordered, a statement of the matter must be served upon the justice or judge against whom the proceeding is brought. The Commission, in its discretion, may suspend a justice or judge from the exercise of his office pending the determination of the proceedings before the Commission. Any justice or judge whose removal is sought as liable to indictment or punishment according to law. A justice or judge retired for disability in accordance with this section is entitled thereafter to receive such compensation as the legislature may provide. Number 10. If a proceeding is brought against a justice of the Supreme Court, no justice of the Supreme Court may sit on the Commission for that proceeding. If a proceeding is brought against a judge of the Court of Appeals, no judge of the Court of Appeals may sit on the Commission for that proceeding. If a proceeding is brought against a district judge, no district judge from the same judicial district may sit on the Commission for that proceeding. If a proceeding is brought against a justice of the peace, no justice of the peace from the same township may sit on the Commission for the proceeding. If a proceeding is brought against a municipal judge, no municipal judge from the same city may sit on the Commission for that proceeding. If an appeal is taken from an action of the Commission to the Supreme Court, any justice who sat on the Commission for that proceeding is disqualified from participating in the consideration or decision of the appeal. When any member of the Commission is disqualified by this subsection, the Supreme Court shall appoint a substitute from among the eligible judges. Number 11. The Commission may A. Designate for each hearing an attorney or attorneys at law to act as counsel to conduct the proceedings. B. Summon witnesses to appear and testify under oath and compel the production of books, papers, documents, and records. C. Grant immunity from prosecution or punishment when the Commission deems it necessary and proper in order to compel the giving of testimony under oath and the production of books, papers, documents, and records, and D. Exercise such further powers as the legislature may from time to time confer upon it. Article 7. Impeachment and removal from office. Section 1. Impeachment trial and conviction. The Assembly shall have the sole power of impeaching. The concurrence of a majority of all the members elected shall be necessary to an impeachment. All impeachment shall be tried by the Senate, and when sitting for that purpose, the senator shall be upon oath or affirmation to do justice according to law and evidence. The Chief Justice of the Supreme Court shall preside over the Senate while sitting to try the governor or lieutenant governor upon the impeachment. No person shall be convicted without the concurrence of 2/3 of the senators elected. Section 2. Officers subject to impeachment. The governor and other state and judicial officers, except justices of the peace, shall be liable to impeachment for the misdemeanor or malfeasance in office. But judgment in such case shall not extend further than the removal from office and disqualification to hold any office of honor, profit, or trust under this state. The party, whether convicted or acquitted, shall nevertheless be liable to indictment, trial, judgment, and punishment according to the law. Section 3. Removal of justices of Supreme Court, judges of the Courts of Appeals, and judges of district courts. For any reasonable cause to be entered on the journals of each House, which may or may not be sufficient grounds for impeachment, the justices of the Supreme Court, the judges of the Court of Appeals, and the judges of the district courts must be removed from office on the vote of 2/3 of the members elected to each branch of the legislature. The justice or judge complained of must be served with a copy of the complaint against him and have an opportunity of being heard in the person or by counsel in his defense. No member of either branch of legislature is eligible to fill the vacancy occasioned by such removal. Section 4. Removal of other civil officers. Provision shall be made by law for the removal of office of any civil officer other than those in the article previously specified for malfeasance or nonfeasance in the performance of his duties. Article 8. Municipal and other corporations. Section 1. Corporations formed under general laws, municipal corporations formed under special acts. The legislature shall pass no special act in any manners relating to the corporate powers except for municipal purposes, but corporations may be formed under general laws, and all such laws may from time to time be altered or repealed. Section 2. Corporate property, subject to taxation and exemptions. All real property and possessionary rights to the same, as well as personal property in the state, belonging to corporations is now existing or hereafter created shall be subject to taxation. The same as property of individuals, provided that the property of corporations formed for municipal, charitable, religious, or educational purposes may be exempted by law. Section 3. Individual liability of corporators. Dues from corporations shall be secured by such means as may be prescribed by law, provided that corporators in corporations formed under the laws of this state shall not be individually liable for the debts or liabilities of such corporations. Section 4. Regulation of corporations incorporated under territorial law. Corporations created by or under the laws of the Territory of Nevada shall be subject to the provisions of such laws until the legislature shall pass laws regulating the same, in pursuance of the provisions of this Constitution. Section 5. Corporations may sue and be sued. Corporations may sue and be sued in all courts, in like manner as individuals. Section 6. Circulation of certain banknotes or paper as money prohibited. No banknotes or paper of any kind shall ever be permitted to circulate as money in this state, except the federal currency, and the notes of banks authorized under the laws of Congress. Section 7. Eminent domain by corporations. No right-of-way shall be appropriated to the use of any corporation until full compensation be first made or secured therefor. Section 8. Municipal corporations formed under general laws. The legislature shall provide for the organization of cities and towns by general laws and shall restrict their power of taxation, assessment, borrowing money, contracting debts, and loaning their credit, except for procuring supplies of water, provided, however, that the legislature may, by general laws, in the manner and to the extent therein provided, permit and authorize the electors of any city or town to frame, adopt, amend, or charter for its own government, or to amend any existing charter of such city or town. Section 9. Gifts or loans of public money to certain corporations prohibited. The state shall not donate or loan money, or its credit, subscribe to or be interested in the stock of any company, association, or corporation, except corporations formed for educational or charitable purposes. Section 10. Loans of public money to or ownership of stock in certain corporations by county or municipal corporations prohibited. No county, city, town, or other municipal corporation shall become a stockholder in any joint stock company, corporation, or association, whatever, or loan its credit in any aid of any such company, corporation, or association except railroad corporations, companies, and associations. Article 9. Finance and State Debt. Section 1. Fiscal Year. The fiscal year shall commence on the first day of July of each year. Section 2. Annual tax for state expenses, trust funds for industrial accidents, occupational diseases, administration of public employees, retirement system. Number 1. The legislature shall provide by law for an annual tax sufficient to defray the estimated expenses of the state for each fiscal year and whenever the expenses of any year exceed their income. The legislature shall provide for levying a tax sufficient with other sources of income to pay the deficiency, as well as the estimated expenses of such ensuing year or 2 years. Number 2. Any money paid for the purpose of providing compensation for industrial accidents and occupational diseases, and for the administrative expenses incidental thereto, and for the purposes of funding and administering a public employees' retirement system, must be segregated in proper accounts in the state treasury, and such money must never be used for any other purposes, and they are hereby declared to be trust funds for the uses and purposes hereon specified. Number 3. Any money paid for the purposes of funding and administering a public employees' retirement system must not be loaned to the state or invested to purchase any obligations of the state. Number 4. The public employees' retirement system must be governed by a public employees' retirement board. The board shall employ an executive officer who serves at the pleasure of the board. In addition to any other employees authorized by the board shall employ an independent actuary. The board shall adopt an actuarial assumptions based upon the recommendations made by the independent actuary it employs. Section 3. State indebtedness, limitations, and exceptions. The state may contract public debts, but such debts shall never, in the aggregate, exclusive of interest, exceed the sum of 2% of the assessed valuation of the state, as shown by the reports of the county assessors to the state controller, except for the purpose of defraying extraordinary expenses as hereafter mentioned. Every such debt shall be authorized by law for some purpose or purposes to be distinctly specified therein, and every such law shall provide for levying an annual tax sufficient to pay the interest semi-annually, and the principal within 20 years from the passage of such law, and shall specially appropriate the proceeds of said taxes to the payment of said principal and interest. And such appropriation shall not be repealed, nor the taxes postponed or diminished until the principal and interest of said debts shall have been wholly paid. Every contract of indebtedness entered or assumed by or on behalf of the state, when all debts and liabilities amount to said sum before mentioned, shall be void and of no effect except in cases of money borrowed to repeal invasion, suppress insurrection, defend the state in the time of war, or, if hostilities be threatened, provide for the public defense. The state, notwithstanding the foregoing limitations, may, pursuant to the authority of the legislature, make and enter all contracts necessary, expedient, or advisable for the protection and preservation of any of its property or natural resources, or for the purposes of obtaining the benefits thereof, however arising and whether arising by or through any undertaking or project of the United States, or by through any treaty or compact between the states or otherwise. The legislature may from time to time make such appropriations as may be necessary to carry out the obligations of the state under such contracts, and shall levy such tax as may be necessary to pay the same or carry them into effect. Section 4. Assumption of debts of county, city, or corporation by state. The state shall never assume the debts of any county, town, city, or other corporation whatever, unless such debts have been created to repeal invasion, suppress insurrection, or to provide for the public defense. Section 5. Proceeds from fees for licensing and registration of motor vehicles and excise taxes on fuel reserved for construction, maintenance, and repair of public highways. Exception. The proceeds from the imposition of any license or registration fee and other charge with respect to the operation of any motor vehicle upon any public highway in the state, and the proceeds from imposition of any excise tax on gasoline or other motor vehicle fuel shall, except of the cost of administration, be used exclusively for the construction, maintenance, and repair of public highways of this state. The provisions of this section do not apply to the proceeds of any tax imposed upon motor vehicles by the legislature in lieu of an valerian property tax. Article 10. Taxation. Section 1. Uniform and equal rate of assessment and taxation, valuation of property, exceptions and exemptions, inheritance, and personal income taxes prohibited. The legislature shall provide by law for a uniform and equal rate of assessment and taxation, and shall prescribe such regulations as shall secure a just valuation for taxation of all property, real, personal, or possessionary, except mines and mining claims, which shall be assessed and taxed only as provided in Section 5 of this article. Number 2. Shares of stock, bonds, mortgages, notes, bank deposits, book accounts, and credits and securities, and choses in action like character, are deemed to represent interest in property already assessed and taxed, either in Nevada or elsewhere, and shall be exempt. Number 3. The legislature may constitute agricultural and open space real property having a greater value for another use than that of which it is being used, as a separate class for taxation purposes, and may provide a separate uniform plan for appraisal and the valuation of such property for assessment purposes. If such plan is provided, the legislature shall provide for the retroactive assessment for a period of not less than 7 years when agricultural and open space real property is converted to a higher use conforming to the use for which other nearby property is used. Number 4. Personal property which is moving in interstate commerce through or over the territory of the state of Nevada, or which has consigned to a warehouse, public or private, within the state of Nevada from outside the state of Nevada for storage in transit to a final destination outside the state of Nevada, whether specified when transportation begins or afterward, shall be deemed to have acquired no situs in Nevada for purposes of taxation, and shall be exempt from taxation. Such property shall not be deprived of such exemption because while in the warehouse the property is assembled, bound, joined, processed, disassembled, divided, cut, broken in bulk, relabeled, or repackaged. Number 5. The legislature may exempt motor vehicles from the provisions of the tax required by this section, and in lieu thereof, if such exemption is granted, shall provide for a uniform and equal rate of assessment and taxation of motor vehicles, which rate shall not exceed 5 cents on $1 of assessed valuation. Number 6. The legislature shall provide by law for a progressive reduction in the tax upon business inventories by 20% in each year following the adoption of this provision, and after the expiration of the 4th year, such inventories are exempt from taxation. The legislature may exempt any other personal property, including livestock. Number 7. No inheritance tax shall ever be levied. Number 8. The legislature may exempt by law property used for municipal and educational, literary, scientific, or other charitable purposes to encourage the conservation of energy or the substitution of other sources for fossil fuel sources of energy. Number 9. No income tax shall be levied upon the wages or personal income of natural persons, notwithstanding the foregoing provision, and except as otherwise provided in subsection 1 of this section. Taxes may be levied upon the income or revenue of any business in whatever form it may be conducted for profit in this state. Number 10. The legislature may provide by law for an abatement of the tax upon an exemption of part of the assessed value of a single-family residence occupied by the owner to the extent necessary to avoid severe economic hardship to the owner of the residence. Section 2. Total tax levy for public purposes limited. The total tax levy for all public purposes, including levies for bonds within the state or any subdivision thereof, shall not exceed 5 cents on the dollar of assessed valuation. Section 3. Household goods and furniture of single household exempt from taxation. All household goods and furniture used by a single household and owned by a member of that household are exempt from taxation. Section 3A. Food exempt from taxes on retail sales exceptions. The legislature shall provide by law for: Number 1. The exemption of food for human consumption from any tax upon the sale, storage, use, or consumption of tangible personal property. And Number 2. These commodities to be excluded from any such exemption. A. Prepared food intended for immediate consumption. And B. Alcoholic beverages. Section 3B. Durable medical equipment, oxygen delivery equipment, and mobility enhancing equipment exempt from taxes on retail sales. The legislature shall provide by law for the exemption of durable medical equipment, oxygen delivery equipment, and mobility enhancing equipment prescribed for human use by a licensed provider of healthcare acting within his or her scope of practice from any tax upon the sale, storage, or use or consumption of tangible personal property. Section 4. Taxation of estates taxed by United States limitations. The legislature may provide by law for the taxation of estates taxed by the United States, but only to the extent of any credit allowed by federal law for the payment of the state tax and only for the purpose of education, to be divided between the common schools and the state university for their support and maintenance. The combined amount of these federal and state taxes may not exceed the estate tax which would be imposed by federal law alone. If another state of the United States imposes and collects death taxes against an estate which is taxable by the state of Nevada under this section, the amount of the estate tax to be collected by the state of Nevada must be reduced by the amount of the death taxes collected by the other state. Any lien for the estate tax attaches no sooner than the time when the tax is due and payable, and no restriction on possession or use of the descendant's property may be imposed by law before the time when the tax is due and payable in full under the federal law. The state of Nevada shall: Number 1. Accept the determination by the United States of the amount of the taxable estate without further audit. Number 2. Accept payment of the tax in installments proportionate to any which may be permitted under federal law. Number 3. Impose no penalty for such a deferred payment. Number 4. Not charge interest on deferred or belated payment at any rate higher than may be provided in similar circumstances by federal law. Section 5. Tax on proceeds of minerals, appropriation to counties, and apportionment assessments and taxation of mines. Number 1. The legislature shall provide by law for a tax upon the net proceeds of all minerals, including oil, gas, and other hydrocarbons, extracted in this state as a rate not to exceed 5% of the net proceeds. No other tax may be imposed upon a mineral or its proceeds until the identity of the proceeds as such is lost. Number 2. The legislature shall appropriate to each county the sum which would be produced by levying a tax upon the entire amount of the net proceeds taxed in each taxing district in the county at the rate levied in that district upon the assessed valuation of real property. The total amount appropriated to each county must be apportioned among the respective governmental units and districts within it, including the county itself and the school districts, in the same proportion as they share in the total taxes collected on property according to value. Number 3. Each patented mine or mining claim must be assessed and taxed as other real property is assessed and taxed, except that no value may be attributed to any mineral known or believed to underlie it, and no value may be attributed to the surface of a mine or claim if $100 worth of labor has been actually performed on the mine or claim during the year preceding the assessment. Section 6. Enactment of exemption from ad valorem tax on property or excise tax on retail sales. Number 1. The legislature shall not enact any exemption from any ad valorem tax on property or excise tax on the sale, storage, use, or consumption of tangible personal property sold at retail unless the legislature finds that the exemption A. will achieve a bona fide social or economic purpose and the benefits of the exemption are expected to exceed any adverse effect of the exemption on the provisions of services to the public by the state or a local government that would otherwise receive revenue from the tax from which the exemption would be granted, and B. will not impair adversely the ability of the state or local government to pay when due all interest and principal and any outstanding bonds or any other obligations for which revenue from the tax from which the exemption would be granted was pledged. Number 2. And enacting an exempt from any ad valorem tax on property or excise tax on the sale, storage, use, or consumption of tangible personal property sold at retail, the legislature shall A. to ensure that the requirements for claiming the exemption are as similar as practicable for similar classes of taxpayers, and B. provided a specific date on which the exemption will cease to be effective. Article 11. Education. Section 1. The legislature to encourage education, appointment, term, and duties of superintendent of public instruction. The legislature shall encourage by all suitable means the promotion of intellectual, literary, scientific, mining, mechanical, agricultural, and moral improvements, and provide for a superintendent of public instruction, and by the law prescribe the manner of appointment, term of office, and the duties thereof. Section 2. Uniform System of Common Schools. The legislature shall provide for a uniform system of common schools by which a school shall be established and maintained in each school district at least 6 months in every year, and any school district which will allow instruction of a sectarian character therein may be deprived of its proportion of interest of public schools funding during such neglect or infraction, and the legislature may pass such laws as will tend to secure a general attendance of the children in each school district upon said public schools. Section 3. Pledge of certain property and money, escheated estates and fines collected under penal laws for educational purposes, apportionment and use of interest. All lands granted by Congress to the state for educational purposes, all estates that escheat to the state, all property given or bequeathed to the state for educational purposes, and the proceeds derived from these sources, together with that percentage of these proceeds from the sale of federal lands which has been granted by the Congress to the state without restriction for educational purposes, and for all fines collected on the penal laws of the state are hereby pledged for educational purposes, and the money therefrom must be transferred to other funds for other uses. The interest only earned on the money derived from these sources must be apportioned by the legislature among the several counties for educational purposes, and, if necessary, a portion of that interest may be apportioned for the support of the state university, and by any of that interest which is unexpected at the end of any year must be added to the principal sum pledged for educational purposes. Section 4. Establishment of state university controlled by the Board of Regents. The legislature shall provide for the establishment of a state university, which shall embrace departments for agriculture, mechanic arts, and mining to be controlled by a Board of Regents, whose duties shall be prescribed by law. Section 4B. Establishment of state university, legislature to provide by law for the governance, control, and management of state university and protection of academic freedom. Number 1. The legislature shall provide for the establishment of a state university which shall embrace departments for agriculture, mechanic arts, and mining, and other departments deemed appropriate for the state university. Number 2. The legislature shall provide by law for A. The governance, control, and management of the state university. B. The reasonable protection of individual academic freedom for persons who are enrolled in or who are employees or contractors of the state university and other public institutions of higher education in this state, in order to facilitate the policies of Section 1 of this article, to encourage by all suitable means the promotion of intellectual, literary, scientific, mining, mechanical, agricultural, and ethical and other educational improvements. Section 5. Establishment of normal schools and grade of schools, oath of teachers and professors. The legislature shall have power to establish normal schools and such different grades of schools from the primary department to the university, as in their discretion they may deem necessary, and all professors in said university or teachers in said schools of whatever grade shall be required to take and subscribe to the oath as prescribed in Article 15 of this Constitution. No professor or teacher who fails to comply with the provisions of any law framed in accordance with the provisions of this section shall be entitled to receive any portion of the public moneys set apart for school purposes. Section 6. Support of university and common schools by direct legislative appropriation, priority of appropriations. Number 1. In addition to other means provided in the support and maintenance of said university and common schools, the legislature shall provide for their support and the maintenance by direct legislative appropriation from the general fund upon the presentation of budgets in the manner required by law. Number 2. During a regular session of legislature, before any other appropriation is enacted, to fund a portion of the state's budget for the next ensuing biennium, the legislature shall enact one or more appropriations to provide the money the legislature deems to be sufficient, when combined with the local money reasonably available for this purpose, to fund the operation of public schools in the state for kindergarten through grade 12 for the next ensuing biennium for the population reasonably estimated for that biennium. Number 3. During a special session of legislature that is held between the end of a regular session in which the legislature has not enacted the appropriation or appropriations required by subsection 2 to fund education for the next ensuing biennium, and the first day of that next ensuing biennium, before any other appropriation is enacted other than appropriations required to pay the cost of that special session, the legislature shall enact one or more appropriations to provide the money the legislature deems to be sufficient when combined with the local money reasonably available for this purpose, to fund the operation of the public schools in the state for kindergarten through grade 12 for the next ensuing biennium for the population reasonably estimated for that biennium. Number 4. During a special session of the legislature that is held in a biennium for which the legislation has not enacted the appropriation or appropriations required by subsection 2 to fund education for the biennium in which the special session is being held, before any other appropriation is enacted other than appropriations required to pay the cost of that special session, the legislature shall enact one or more appropriations to provide the money the legislature deems to be sufficient when combined with the local money reasonably available for this purpose, to fund the operation of the public schools in the state for kindergarten through grade 12 for the population reasonably estimated for the biennium in which the special session is held. Number 5. Any appropriation of money enacted in violation of subsection 2, 3, or 4 is void. Number 6. As used in this section, biennium means a period of 2 fiscal years beginning on July 1st of an odd-numbered year and ending on June 30th of the next ensuing odd-numbered year. Section 7. Board of Regents, Election and Duties. The Governor, Secretary of State, and Superintendent of Public Instruction shall for the first 4 years and until their successors are elected and qualified constitute a board of regents to control and manage the affairs of the university and the funds of the same under such regulations as may be provided by law. But the legislature shall at its regular session next preceding the expiration of the term of office of said Board of Regents provide for the election of a new Board of Regents and define their duties. Section 8. Immediate organization and maintenance of State University. The Board of Regents shall, from the interest accruing from the first funds which come under their control, immediately organize and maintain the said mining department in such manner as to make it most effective and useful, provided that all proceeds of the public lands donated by the Act of Congress approved July 2nd, A.D. 1862, for a college for the benefit of agriculture, the mechanic arts, and including military tactics shall be invested by the said Board of Regents in a separate fund to be appropriated exclusively for the benefit of the first named departments to their university as set forth in Section 4 above. And the legislature shall provide that if, through neglect or any other contingency, any portion of the fund so set apart shall be lost or misappropriated, the state of Nevada shall replace that amount so lost or misappropriated in said fund so that the principal of said fund shall remain forever undiminished. Section 8. Use of proceeds from public lands donated by Act of Congress for the benefit of certain departments of State University. The proceeds of the public lands donated by the Act of Congress approved July 2nd, 1862, Chapter 130, 12, Stat. 503, and thereafter amended by Act of Congress for a college for the benefit of agriculture, mechanic arts, including military tactics, shall be invested by the state of Nevada in the manner required by law in a separate fund to be appropriated exclusively for the benefit of the first named departments to the State University as set forth in Section 4 of this article. And the legislature shall provide that through neglect or any other contingency, any portion of the fund so set apart is lost or misappropriated, the state of Nevada shall replace said amount so lost or misappropriated in said fund so that the principal of said fund shall remain forever undiminished. Section 9. Sectarian instruction prohibited in common schools and university. No sectarian instruction shall be imparted or tolerated in any school or university that may be established under this Constitution. Section 10. No public money to be used for sectarian purposes. No public funds of any kind or character whatever, state, county, or municipal, shall be used for sectarian purpose. Article 12. Militia. Section 1. Legislature to provide for militia. The legislature shall provide by law for organizing and disciplining the militia of the state for the effectual encouragement of volunteer corps and the safekeeping of public arms. Section 2. Power of governor to call out militia. The governor shall have the power to call out the militia to execute the laws of the state or to suppress insurrection or repeal invasion. Article 13. Public institutions. Section 1. Institutions for insane, blind, deaf, and dumb to be fostered and supported by state. Institutions for the benefit of the insane, blind, and deaf, and dumb, and such other benevolent institutions as the public good may require, shall be fostered and supported by the state, subject to such regulations as may be prescribed by law. Section 2. State prison. Establishment and maintenance juvenile offenders. A state prison shall be established and maintained in such manner as may be prescribed by law, and provision made by law for the establishment and maintenance of a house of refuge for juvenile offenders. Section 3. County Public Welfare. Repealed in 1937. Article 14. Boundary. Section 1. Boundary of the State of Nevada. The boundary of the state of Nevada is as follows. Commencing at a point formed by the intersection of the 43rd degree of longitude west from Washington with the 42nd degree of north latitude, thence due east along the 42nd degree of north latitude to its intersection with the 37th degree of longitude west from Washington, then south on the 37th degree of longitude west from Washington to its intersection with the middle line of the Colorado River of the west, thence down the middle line of the Colorado River of the west to its intersection with the eastern boundary of the state of California, thence in a northwesterly direction along the eastern boundary line of the state of California to the 43rd degree of longitude west from Washington, thence north along the 43rd degree of west longitude and the eastern boundary line of the state of California to the place of beginning. All territory lying west of and adjoining the boundary line herein prescribed, which the state of California may relinquish to the territory of the state of Nevada, shall thereupon be embraced within and constitute a part of the state. Article 15. Miscellaneous Provisions. Section 1. Carson City, Seat of Government. The seat of government shall be at Carson City, but no appropriation for the erection or purchase of capital buildings shall be made during the next 3 years. Section 2. Oath of Office. Members of the legislature and all officers, executive, judicial, and ministerial, shall, before they enter upon the duties of the respective offices, take and subscribe to the following oath. I do solemnly swear or affirm that I will support, protect, and defend the Constitution and government of the United States, and the Constitution and government of the state of Nevada, against all enemies, whether domestic or foreign, and that I will bear true faith, allegiance, and loyalty to the same, any ordinance, resolution, or law of any state notwithstanding, and that I will well and faithfully perform all of the duties of the office of, on which I am about to enter, so help me God, under the pains and penalties of perjury. Section 3. Eligibility for public office. Number 1. No person shall be eligible to any office who is not a qualified elector under this Constitution. Number 2. No person may be elected to any state office or local governing body who has served in that office, or at the expiration of his current term, if he is so serving, will have served 12 or more years, unless the permissible number of terms or duration of service is otherwise specified in this Constitution. Section 4. Perpetuities. Eleemosynary purposes. No perpetuities shall be allowed except for eleemosynary purposes. Section 5. Time of general election. The general election shall be held on the Tuesday next after the first Monday of November. Section 6. Number of members of legislature limited. The aggregate number of members of both branches of the legislature shall never exceed 75. Section 7. County offices at county seats. All county officers shall hold their offices at the county seat of their respective counties. Section 8. Publication of general statuses. Publication and effective date of the decisions of Supreme Court and Court of Appeals. The legislature shall provide for the speedy publication of all statute laws of a general nature and such decisions of the Supreme Court and the Court of Appeals as it may deem expedient. All laws and judicial decisions must be free for publication by any person. No judgment of the Supreme Court or the Court of Appeal shall take effect and be operative until the opinion of the court in such case is filed with the clerk of said court. Section 9. Increase or decrease of compensation of officers whose compensation is fixed by Constitution. The legislature may, at any time, provide by law for increasing or diminishing the salaries or compensation of any of the officers whose salaries or compensation is fixed in this Constitution, provided no such change of salary or compensation shall apply to any officer during the term for which he may have been elected. Section 10. Election or appointment of officers. All officers whose election or appointment is not otherwise provided for shall be chosen or appointed as may be prescribed by law. Section 11. Term of office when not fixed by Constitution. Limitation, municipal officers and employees. The tenure of any office not herein provided for may be declared by law, or, when not so declared, such office shall be held during the pleasure of the authority making the appointment. But the legislature shall not create any office to tenure for which shall be longer than 4 years, except as herein otherwise provided in this Constitution. In the case of any officer or employee of any municipality governed under a legally adopted charter, the provisions of such charter, with reference to the tenure of office or dismissal from office of any such officer or employee, shall control. Section 12. Certain state officers to keep offices at Carson City. The Governor, Secretary of State, State Treasurer, State Controller, and the Clerk of the Supreme Court shall keep their respective offices at the seat of government. Section 13. Census by Legislature and Congress. Basis of representation in houses of legislature. The enumeration of the inhabitants of this state shall be taken under the direction of the legislature if deemed necessary in A.D. 1865, A.D. 1867, A.D. 1875, and every 10 years thereafter, and these enumerations together with the census that may be taken under the direction of the Congress of the United States in A.D. 1870, and every subsequent 10 years shall serve as the basis of representation in both houses of legislature. Section 14. Election by plurality. A plurality of votes given at an election by the people shall constitute a choice where not otherwise provided by this Constitution. Section 15. Merit system governing employment in the executive branch of the state government. The legislature shall provide by law for a state merit system governing the employment of employees in the executive branch of state government. Section 16. Payment of minimum compensation to employees. A. Each employer shall pay a wage to each employee of not less than the hourly rate set forth in this section. The rate shall be $5.15 per hour worked. If the employer provides health benefits as described herein, or $6.15 per hour if the employer does not provide such benefits. Offering health benefits within the meaning of this section shall consist of making health insurance available to the employees, for the employee, and the employee's dependents at a total cost to the employee for premiums of not more than 10% of the employee's gross taxable income from the employer. These rates of wage shall be adjusted by the amount of increases in the federal minimum wage over $5.15 per hour, or, if greater, by the cumulative increases in the cost of living. The cost of living increase shall be measured by the percentage increase as of December 31st and any year over the level as of December 31st, 2004 of the Consumer Price Index as published by the Bureau of Labor Statistics, U.S. Department of Labor, or the successor index or federal agency. No CPI adjustment for any 1 year period may be greater than 3%. The governor or the state agencies designated by the governor shall publish a bulletin by April 1st of each year announcing the adjusted rates, which shall take effect the following July 1st. Such bulletin will be made available to all employers and to any other person who has filed with the governor or the designated agency a request to receive such notice, but lack of notice shall not excuse noncompliance with this section. An employer shall provide written notification of the rate of adjustments to each of its employees and make the necessary payroll adjustments by July 1st following the publication of the bulletin. Tips and gratuities received by employees shall not be credited as being any part of offset against the wage rates required by this section. B. The provisions of this section may not be waived by agreement between an individual employee and an employer. All of the provisions of this section, or any part hereof, may be waived in a bona fide collective bargaining agreement, but only if the waiver is explicitly set forth in such agreement in clear and ambiguous terms. Unilateral implementation of terms and conditions of employment may be either party to a collective bargaining relationship shall not constitute or be permitted as a waiver of all or any part of the provisions of this section. An employer shall not discharge, reduce the compensation of, or otherwise discriminate against any employee for using any civil remedies to enforce this section or otherwise asserting his or her rights under this section. An employee claiming violation of this section may bring an action against his or her employer in the courts of this state to enforce the provisions of this section and shall be entitled to all remedies available under the law or in equity appropriate to remedy any violation of this section, including but not limited to back pay, damages, reinstatement, or injunctive relief. An employee who prevails in any action to enforce this section shall be awarded his or her reasonable attorney's fees and costs. C. As used in this section, employee means any person who is employed by an employer as identified herein, but does not include an employee who is under 18 years of age. Employed by a nonprofit organization for after-school or summer employment or as a trainee for a period not longer than 90 days. Employer means any individual, proprietorship, partnership, joint venture, corporation, limited liability company, trust, association, or other entity that may employ individuals or enter into contracts of employment. D. If any provision of this section is declared illegal, invalid, or inoperative, in whole or in part, by the final decision of any court of competent jurisdiction, the remaining provisions and all portions not declared illegal, invalid, or inoperative shall remain in full force or effect. And no such determination shall invalidate the remaining sections or portions of the sections of this section. Section 16, Payment of Minimum Compensation to Employees. Number 1, except as otherwise provided in this section, beginning July 1st, 2024, each employer shall pay a wage to each employee of not less than $12 per hour's worked. Number 2, if at any time the amount of federal minimum wage is greater than $12 per hour worked, each employer must pay a wage to each employee of not less than the hourly rate established by the federal minimum wage. Number 3, the legislature may establish by law a minimum wage that an employer must pay to each employee that is greater than hourly rate required by this section. 4, tips and gratuities received by employees shall not be credited as being any part or offset against the wage rates required by this section. Number 5, except as otherwise provided in this section, the provisions of this section may not be waived by agreement between an employee and his or her employer. All of the provisions of this section or any part hereof may be waived in a bona fide collective bargaining agreement, but only if the waiver is explicitly set forth in such agreement in clear and ambiguous terms. Unilateral implementation of terms and conditions of the employment by either party to a collective bargaining relationship shall not constitute or be permitted as a waiver of all or any part of the provisions of this section. Number 6, an employer shall not in any manner discharge, reduce the compensation, or otherwise discriminate against any employee for using any civil remedies to enforce this section or otherwise asserting his or her rights under this section. 7, an employee claiming violation of this section is entitled to bring an action against his or her employer in the courts of this state to enforce the provisions of this section and shall be entitled to all remedies available under the law or in equity appropriate to the remedy any violation of this section, including but not limited to back pay, damages, reinstatement, or injunctive relief. An employee who prevails in any action to enforce this section shall be awarded his or her reasonable attorney's fees and costs. 8. As used in this section, employee means any person who is employed by an employer as defined herein, but does not include an employee who is under 18 years of age, employed by a nonprofit organization for after-school or summer employment, or as a trainee for a period not longer than 90 days. B. Employer means any individual, proprietorship, partnership, joint venture, corporation, limited liability company, trust, association, or any other entity that may employ individuals or enter into contracts of employment. Number 9. If any provision of this section is declared illegal, invalid, or inoperative, in whole or in part, by the final decision of any court of competent jurisdiction, the remaining provisions in all portions not declared illegal, invalid, or inoperative shall remain in full force or effect, and no such determination shall invalidate the remaining sections or portions of the sections of this section. Article 16. Amendments. Section 1. Constitutional amendments, procedure, concurrent, and consecutive amendments. Number 1. Any amendment or amendments to this Constitution may be proposed in the Senate or Assembly, and if the same shall be agreed to by a majority of all the members elected to each of the two houses, such proposed amendment or amendments shall be entered on their respective journals, with the yeas and nays taken thereon, and referred to the legislature then next to be chosen, and shall be published for 3 months next preceding the time of making such choice. And if the legislature, next chosen as aforesaid, such proposed amendment or amendments shall be agreed to by a majority of all the members elected to each house, then it shall be the duty of the legislature to submit such proposed amendment or amendments to the people, in such manner and at such time as the legislature shall prescribe. And if the people shall approve and ratify such amendment or amendments by a majority of the electors qualified to vote for members of the legislature, voting thereon, such amendment or amendment shall, unless precluded by subsection 2 or section 2 of Article 19 of this Constitution, become a part of the Constitution. Number 2. If 2 or more amendments which affect the same section of the Constitution are ratified by the people pursuant to this section at the same election. A. If all can be given effect without contradiction in substance, each shall become a part of the Constitution. B. If one or more contradict in substance the other or others, that amendment which receive the largest favorable vote, and any other ratified amendment or amendments comparable with it shall become a part of the Constitution. Number 3. If after the proposal of an amendment, another amendment is ratified pursuant to this section which affects the same section of the Constitution but is compatible with the proposed amendment, the next legislature, if it agrees to the proposed amendment, shall submit each proposal to the people as a further amendment to the amendment section. If after the proposal of the amendment, another amendment is ratified pursuant to this section which contradicts in substance the proposed amendment, such proposed amendment shall not be submitted to the people. Section 2. Convention for Revision of Constitution Procedure. If at any time the legislature, by a vote of 2/3 of the members elected to each house, shall determine that it is necessary to cause a revision of this entire Constitution, they shall recommend to the electors at the next election for members of legislature to vote for or against a convention. And if it shall appear that a majority of the electors voting at such election shall have voted in favor of calling a convention, the legislature shall, at its next session, provide by law for calling a convention to be holden within 6 months after the passage of such law. And such convention shall consist of a number of members not less than that of both branches of the legislature. In determining what is a majority of the electors voting at such election, reference shall be had to the highest number of votes cast at such election for the candidates of any office or any question. Article 17. Schedule. Section 1. Saving existing rights and liabilities. That no inconvenience may arise by reason of a change from a territorial to a permanent state government, it is declared that all rights, actions, prosecutions, judgments, claims, and contracts, as well as of individuals as bodies of corporate, include counties, towns, and cities, shall continue as if no change had taken place, and all process which may issue under the authority of the Territory of Nevada, previous to its admission into the Union as one of the United States, shall be as valid as if it issued in the name of the state of Nevada. Section 2. Territorial laws to remain in force. All laws of the territory of Nevada in force at the time of the admission of this state, not repugnant to this Constitution, shall remain in force until they expire by their own limitations or be altered or repealed by the legislature. Section 3. Fines, penalties, and forfeitures to inure the state. All fines, penalties, and forfeitures occurring to the territory of Nevada or to the people of the United States in the territory of Nevada shall inure to the state of Nevada. Section 4. Existing obligations and pending suits. All recognizances heretofore taken to which may be taken before the change from a territory to a state government shall remain valid, and shall pass to and may be prosecuted in the name of the state, and all bonds executed to the governor of the territory and to any other officer of the court, or in his or their official capacity, or to the people of the United States in the territory of Nevada, shall pass to the governor or other officer of court, and his or her their successors in office for the uses therein respectively expressed, and may be sued on and recovery had accordingly, and all property, real, personal, or mixed, and all judgments, bonds, specialties, chosen in action, claims and debts of whatsoever description, and all records and public archives of the territory of Nevada shall issue to invest in the state of Nevada, and may be sued for and recovered in the same manner and to the same extent by the state of Nevada, as the same could have been by the territory of Nevada. All criminal prosecutions and penal actions which may have arisen or which may arise before the change from a territory to a state government, and which shall then be pending, shall be prosecuted to judgment and the execution in the name of the state. All offenses committed against the laws of the territory of Nevada before the change from a territory to a state government, and which shall not be prosecuted before such change, may be prosecuted in the name and by the authority of the state of Nevada, with like effect as though such change had not taken place, and all penalties incurred shall remain the same as if this Constitution had not been adopted. All actions at law and suits in equity and other legal proceedings which may be pending in any of the courts of the territory of Nevada at the time of the change from a territory to a state government may be continued and transferred to, and to determine by any court of the state which shall have jurisdiction of the subject matter thereof. All actions at law and suits in equity and all other legal proceedings which may be pending in any of the courts of the territory of Nevada at the time of the change from a territory to a state government shall be continued after transfer to, and may be prosecuted to judgment and execution in any court of the state which shall have jurisdiction of the subject matter thereof. And all books, papers, and records relating to the same shall be transferred in like manner to such court. Section 5. Salaries of state officers for first term of office. For the first term of office succeeding the information of a state government, the salary of the governor shall be $4,000 per annum. The salary of the Secretary of State shall be $3,600 per annum. The salary of the State Controller shall be $3,600 per annum. The salary of the State Treasurer shall be $3,600 per annum. The salary of the Surveyor General shall be $1,000 per annum. The salary of the Attorney General shall be $2,500 per annum. The salary of the Superintendent of Public Instruction shall be $2,000 per annum. The salary of each judge of the Supreme Court shall be $7,000 per annum. The salaries of the foregoing officers shall be paid quarterly out of the state treasury. The pay of the state senators and members of assembly shall be $8 per day for each day of actual service, and 40 cents per mile for mileage going to and returning from the place of meeting. No officer mentioned in this section shall receive any fee perquisites to his own for the performance of any duty connected to his office, to his own use for the performance of any duty connected with his office, or for the performance of any additional duty imposed upon him by law. Section 6. Apportionment of senators and members of assembly. Until otherwise provided by the laws of apportionment of senators and assemblymen in the different counties shall be as follows: to wit, Story County, 4 senators and 12 assemblymen. Douglas County, 1 senator and 2 assemblymen. Esmeralda County, 2 senators and 4 assemblymen. Humboldt County, 2 senators and 3 assemblymen. Lander County, 2 senators and 4 assemblymen. Leon County, 1 senator and 3 assemblymen. Leon and Churchill counties, 1 senator, jointly, Churchill County, 1 assemblyman. Nye County, 1 senator and 1 assemblyman. Ormsby County, 2 senators and 3 assemblymen. Washoe and Roop counties, 2 senators and 3 assemblymen. Section 7. Assumption of territorial debts and liabilities. All debts and liabilities of the Territory of Nevada, lawfully incurred and which remain unpaid at the time of the admission of the state into the Union, shall be assumed by and become the debt of the state of Nevada, provided that the assumption of such indebtedness shall not prevent the state from contracting the additional indebtedness as provided in Section 3 of Article 9 of this Constitution. Section 8. Terms of elected state officers. The terms of the state officers, except judicial, elected at the first election under this Constitution shall continue until the Tuesday after the first Monday of January A.D. 1867 and until the election and qualification of their successors. Section 9. Terms of senators. The senators to be elected at the first election under this Constitution shall draw lots, so that the term of 1/2 of the number, as nearly as may be, shall expire on the day succeeding the general election in A.D. 1866, and the term of the other half shall expire on the day succeeding the general election in A.D. 1868, provided that in drawing lots of all senatorial terms, the senatorial representation shall be allotted, so that in the counties having 2 or more senators, the term thereof shall be divided as nearly as may be between the long and short terms. Section 10. Terms of senators and members of assembly after 1866. At the general election in A.D. 1866 and thereafter, the term of senators shall be for 4 years from the day succeeding such general election, and the members of assembly for 2 years from the day succeeding such general election, and the terms of senators shall be allotted by the legislature in long and short terms as herein before provided, so that 1/2 of the number, as nearly as may be, shall be elected every 2 years. Section 11. Terms of members of assembly elected at first general election or in 1865. The term of the members of assembly elected at the first general election under this Constitution shall expire on the day succeeding the general election in A.D. 1865, and the terms of those elected at the general election in A.D. 1865 shall expire on the day succeeding the general election in A.D. 1866. Section 12. Commencement date of the first 3 legislative sessions, regular sessions of legislature to be held biannually. The first regular session of legislature shall commence on the second Monday of December A.D. 1864, and the second regular session of the same shall commence on the first Monday of January A.D. 1866. And the third regular session of the legislature shall be the first of the biennial sessions, and shall commence Monday of January A.D. 1867, and the regular sessions of the legislature shall be held thereafter biennially. Section 13. Continuation of territory, county, and township officers, probate judges. All county officers under the laws of the Territory of Nevada at the time when the Constitution shall take effect, whose offices are not inconsistent with the provisions of this Constitution, shall continue in office until the first Monday of January A.D. 1867, and until their successors are elected and qualified, and all township officers shall continue in office until the expiration of their terms of office, and until their successors are elected and qualified, provided that the probate judges of several counties, respectively, shall continue in office until the election and qualification of the district judges, of several counties or judicial districts, and provided further that the term of office for the present county officers of Lander County shall expire on the first Monday of January A.D. 1865, except the probate judge of said county, whose term of office shall expire upon the first Monday of December A.D. 1864. And there shall be an election for county officers of Lander County at the general election in November A.D. 1864. And the officers then elected shall hold office from the first Monday of January A.D. 1865 until the first Monday of January A.D. 1867, and until the successors are elected and qualified. Section 14. Duties of certain territorial officers continued. The governor, secretary, treasurer, and superintendent of public instruction of the Territory of Nevada shall each continue to discharge the duties of their respective offices after the admission of the state into the Union, and until the time designated for the qualification of the above-named officers to be elected under the state government, and the territorial auditor shall continue to discharge the duties of his said office until the time appointed for the qualification of the state controller, provided that the said officers shall each receive the salaries and that be subject to the restrictions and conditions provided in this Constitution, and provided further that none of them shall receive to his own use any fees or perquisites for the performance of any duty connected with his office. Section 15. Terms of Supreme Court and District Courts. The terms of the Supreme Court shall, until provisions be made by law, be held at such times as the judges of the said court or a majority of them may appoint. The first terms of the several district courts, except as hereinafter mentioned, shall commence on the first Monday of December A.D. 1864. The first term of the district court in the 5th Judicial District shall commence on the first Monday of December A.D. 1864 in the county of Nye, and shall commence on the first Monday of January A.D. 1865 in the county of Churchill. The terms of the 4th Judicial District Court shall, until otherwise provided by law, be held at the county seat of Washoe County, and the first term thereof commence on the first Monday of December, A.D. 1864. Section 16. Salaries of District Judges. The judges of the several district courts of the state shall be paid as hereinbefore provided salaries at the following rates per annum. First Judicial District, each judge $6,000. Second Judicial District, $4,000. Third Judicial District, $5,000. Fourth Judicial District, $5,000. Fifth Judicial District, $3,600. Sixth Judicial District, $4,000. Seventh Judicial District, $6,000. Eighth Judicial District, $3,600. And Ninth Judicial District, $5,000. Section 17. Alteration of salary of district judges authorized. The salary of any judge in said judicial districts may by law be altered or changed subject to the provisions contained in this Constitution. Section 18. Qualification and terms of certain elective state officers. The governor, lieutenant governor, secretary of state, state treasurer, state controller, attorney general, surveyor general, clerk of the Supreme Court, superintendent of the public instruction to be elected at the first election under this Constitution shall each qualify and enter upon the duties of their respective offices on the first Monday of December succeeding their election, and shall continue in office until the first Tuesday after the first Monday of January A.D. 1867, and until the election and qualification of their successor respectively. Section 19. When justices of the Supreme Court and district judges enter upon duties, the judges of the Supreme Court and district judges to be elected at the first election under this Constitution shall qualify and enter upon the duties of the respective offices on the first Monday of December succeeding their election. Section 20. State officers and district judges to be commissioned by territorial governor, state controller, and treasurer to furnish bonds. All officers of state and the district judges first elected under this Constitution shall be commissioned by the governor of this territory, which commission shall be countersigned by the Secretary of the same, and shall qualify before entering upon the discharge of their duties, before any officer authorized to administer oaths under the laws of this territory. And also the state controller and state treasurer shall each respectively, before they qualify and enter upon the discharge of their duties, execute and deliver to the Secretary of Territory of Nevada an official bond made payable to the people of the state of Nevada in the sum of $30,000 to be approved by the governor of the Territory of Nevada, and shall also execute and deliver to the Secretary of State such other further official bond or bonds as may be required by law. Section 21. Support of county and city officers. Each county, town, city, and incorporated village shall make provision for the support of its own officers, subject to such regulations as may be prescribed by law. Section 22. Vacancies in certain state offices, how filled. In case the office of any state officer, except a judicial officer, shall become vacant before the expiration of the regular term for which he was elected, the vacancy may be filled or by appointed by the governor until it shall be supplied at the next general election, when it shall be filled by an election for the residue of the unexpired term. Section 23. Civil and criminal cases pending in probate courts transferred to district courts. All cases, both civil and criminal, which may be pending and undetermined in the probate courts of the several counties at the time when under the provisions of this Constitution, said probate courts are to be abolished, shall be transferred to and determined by the district courts of such counties respectively. Section 24. The levy of tax limited for 3 years. For the first 3 years after the adoption of this Constitution, the legislature shall not levy a tax for state purposes exceeding 1% per annum on the taxable property in the state, provided the legislature may levy a special tax not exceeding 1/4 of 1% per annum, which shall be appropriated to the payment of the indebtedness of the Territory of Nevada, assumed by the state of Nevada, and for the purpose only until at the said indebtedness is paid. Section 25. Roop County attached to Washoe County. The county of Roop shall be attached to the county of Washoe for judicial, legislative, revenue, and county purposes until otherwise provided by law. Section 26. Constitutional debates and proceedings, publication, payment of reporter. At the first regular session of the legislature to convene under the requirements of this Constitution, provision shall be made by law for paying for the publication of 600 copies of the debates and proceedings of this convention in a book form, to be disposed of as the legislature may direct. And the Honorable J. Neely Johnson, President of the Convention, shall contract for, and A.J. Marsh, official reporter of this convention under the direction of the President, shall supervise the publication of such debates and proceedings. Provision shall be made by law at such first session of the legislature for the compensation of the official reporter of this convention, and he shall be paid in coin or its equivalent. He shall receive for his services in reporting the debates and proceedings $15 per day during the session of the convention, and $7.50 additional for each evening session, and 30 cents per folio of 100 words for pertaining to the same of publication, and for supervising indexing such publication, the sum of $15 per day during the time actually engaged in such service. Article 18. The right of suffrage. Rights of suffrage and office holding. Repealed in 1992. Article 19. Initiative and referendum. Section 1. Referendum for approval or disapproval of statute or resolution enacted by legislature. Number 1. A person who intends to circulate a petition that a statute or resolution or part thereof enacted by the legislature be submitted to a vote of the people, before circulating the petition for signatures, shall file a copy thereof with the Secretary of State. He shall file the copy not earlier than August 1st of the year before the year in which the election will be held. Number 2, whenever a number of registered voters of the state equal to 10% or more of the number of voters who voted in the last preceding general election shall express their wish by filing with the Secretary of State when not less than 120 days before the next general election a petition in the form provided for in Section 3 of this article that any statute or resolution or any part thereof enacted by the legislature be submitted to a vote of the people. The officers charged with the duties of announcing and proclaiming elections and of certifying nominations or questions to be voted upon shall submit the question of approval or disapproval of such statute or resolution or any part thereof to a vote of the voters at the next succeeding election, at which such question may be voted upon by the registered voters of the entire state. The circulation of the petition shall cease on the day of the petition is filed with the Secretary of State or such other date as may be prescribed by the verification of the number of signatures affixed to the petition, whichever is earliest. Number 3, if a majority of the voters voting upon the proposal submitted at such election votes approval for such statute or resolution or any part thereof shall stand as a law of the state and shall not be amended, annulled, repealed, or set aside, suspended, or in any way made inoperative except by the direct vote of the people. If a majority of such voters vote disapproval of such statute or resolution or any part thereof, such statute or resolution or any part thereof shall be void and of no effect. Section 2. Initiative, petition for enactment or amendment of statute or amendment of Constitution, concurrent and consecutive amendments. Number 1. Notwithstanding the provisions of Section 1 of Article 4 of this Constitution, but subject to the limitations of Section 6 of this article, the people reserve themselves the power to propose, by initiative petition, statutes and amendments to the statutes and amendments to this Constitution, and to enact or reject them at the polls. Number 2. An initiative petition shall be in the form required by Section 3 of this article and shall be proposed by a number of registered voters equal to 10% or more of the number of voters who voted at the last preceding general election and not less than 75% of the counties in the state. But the total number of registered voters signing the initiative petition shall be equal to 10% or more of the voters who voted in the entire state at the last preceding general election. Number 3. If the initiative petition proposes a statute or an amendment to a statute, the person who intended to circulate it shall file a copy with the Secretary of State before the beginning circulation and not earlier than January 1st of the year preceding the year in which a regular session of legislature is held. After its circulation, it shall be filed with the Secretary of State not less than 30 days prior to any regular session of the legislature. The circulation of the petition shall cease on the day of the petition is filed with the Secretary of State, such other date as may be prescribed for the verification of the number of signatures affixed to the petition, whichever is earliest. The Secretary of State shall transmit such petition to the legislature as soon as the legislature convenes and organizes. The petition shall take precedence over all other measures except appropriation bills, and the statute or amendment to the statute proposed thereby shall be enacted or rejected by the legislature without change or amendment within 40 days. If the proposed statute or amendment to a statute is enacted by the legislature and approved by the governor in the same manner as other statutes are enacted, such statute or amendment to a statute shall become law, but shall be subject to referendum petition as provided in Section 1 of this article. If the statute or amendment to a statute is rejected by the legislature, or if no action is taken thereon within 40 days, the Secretary of State shall submit the question of approval or disapproval of such statute or amendment to a statute to a vote of the voters at the next succeeding general election. If a majority of the voters voting on such question at such election votes approval of such statute or amendment to a statute, it shall become law and take effect upon completion of the canvass of votes by the Supreme Court. An initiative measure so approved by the voters shall not be amended, annulled, repealed, set aside, or suspended by the legislature within 3 years from the date it takes effect. If a majority of such voters votes disapproval of such statute or amendment to a statute, no further action shall be taken on such petition. If the legislature rejects such proposed statute or amendment, the governor may recommend to the legislature, and the legislature may propose a different measure on the same subject, in which event, after such different measurement has been approved by the governor, the question of approval or disapproval of each measure shall be submitted by the Secretary of State to a vote of the voters at the next succeeding general election. If the conflicting provisions submitted to the voters are both approved by a majority of the voters voting on such measures, the measure which receives the largest number of affirmative votes shall thereupon become law. If at the session of legislature to which an initiative petition proposing an amendment to a statute is presented which the legislature rejects or upon which it takes no action, the legislature amends the statute which the petition proposes to amend in respect, which does not conflict in substance with the proposed amendment, the Secretary of State, in submitting the statute to the voters for approval or disapproval of proposed amendment, shall include the amendment made by the legislature. Number 4, if the initiative petition proposes an amendment to the Constitution, the person who intends to circulate it shall file a copy with the Secretary of State before beginning circulation, and not earlier than September 1st of the year before the year in which the election is to be held. After its circulation, it shall be filed with the Secretary of State not less than 90 days before any regular general election, at which the question of approval or disapproval of such amendment may be voted upon by the voters of the entire state. The circulation of petition shall cease on the day the petition is filed with the Secretary of State or such other's date as prescribed for the verification of the number of signatures affixed to the petition, whichever is earliest. The Secretary of State shall cause to be published in a newspaper of general circulation on 3 separate occasions, in each county in the state, together with any explanatory matter which shall be placed upon the ballot, the entire text of the proposed amendment. If a majority of the voters voting on such question at such election votes disapproval of such amendment, no further action shall be taken on the petition. If a majority of such voters vote approval of such amendment, the Secretary of State shall publish and resubmit the question of approval or disapproval to a vote of the voters at the next succeeding general election in the same manner as such question was originally submitted. If a majority of such voters vote disapproval of such amendment, no further action shall be taken on such petition. If a majority of such voters votes approval of such amendment, it shall, unless precluded by subsection 5 or 6, become a part of this Constitution upon completion of the canvass of votes by the Supreme Court. Number 5, if 2 or more measures which affect the same section of the statute or of the Constitution are finally approved pursuant to this section, or an amendment to the Constitution is finally so approved, and an amendment proposed by the legislature is ratified which affects the same section by the voters at the same section. A. If all can be given effect without contradiction in substance, each shall be given effect. B. If one or more contradict in substance the other or others, the measure which received the largest favorable vote, and any other approved measure compatible with it, shall be given effect. If the one or more measures that contradict in substance the other or others receive the same number of favorable votes, none of the measures that contradict another shall be given effect. Number 6, if at the same election, at the first approval of the constitutional amendment pursuant to this section, another amendment is finally approved pursuant to this section, or an amendment proposed by the legislature is ratified, which affects the same section of this Constitution but is compatible with the amendment given first approval, the Secretary of State shall publish and resubmit at the next general election the amendment given first approval as further amendment to the section as amended by the amendment given final approval or ratified. If the amendment finally approved or ratified contradicts in substance the amendment given first approval, the Secretary of State shall not submit the amendment given first approval to the voters again. Section 3. Referendum and initiative petitions. Contents and form. Signatures and acting clause. Manner of verification of signatures. Number 1. Each referendum petition and initiative petition shall include the full text of the measure proposed. Each signer shall affix thereto his or her signature, residence, address, and the name of the county in which he or she is registered voter. The petition may consist of more than one document, but each document shall have affixed thereto an affidavit made by one of the signers of such document to the effect that all of the signatures are genuine, that each individual who signed such document was at the time of signing a registered voter in the county of his or her residence. The affidavit shall be executed before a person authorized by law to administer oaths in the state of Nevada. The enacting clause of all statutes and amendments proposed by initiative petition shall be, the people of the state of Nevada do enact as follows. The legislature may authorize the Secretary of State and other public officers to use general accepted statistical procedures in conducting a preliminary verification of the number of signatures submitted in connection with a referendum petition or an initiative petition, and for the purpose to require petitions to be filed no more than 65 days earlier than it was otherwise required by this article. Section 4. Powers of initiative, referendum, registered voters of counties and municipalities. The initiative and referendum powers provided for in this article are further reserved to be the registered voters of each county and each municipality as to all local, special, and municipal legislation of any kind or for such county or municipality. In counties and municipalities, initiative petitions may be instituted by a number of registered voters equal to 15% or more of the voters who voted at the last preceding general county or municipal election. Referendum petitions may be instituted by 10% or more of such voters. Section 5. Provisions of Article Self-Executing Legislative Procedures. The provisions of this article are self-executing by the legislature may provide by law for the procedures to facilitate the operation thereof. Section 6. Limitation on initiative making appropriation of requiring expenditure of money. This article does not permit the proposal of any statute or statutory amendment which makes an appropriation or otherwise requires the expenditure of money, unless such statute or amendment also imposes a sufficient tax, not prohibited by the Constitution or otherwise constitutionally provides for raising the necessary revenue.